important that we try to be punctual and to respect the times set. Like I say, I understand that things may intervene, but we must make every effort. I'd like to propose to members that we defer the item of the reading and confirmation of the minutes until after we have taken item 7. My preference is never to defer the minutes to the next meetings, because what I find is that it just results in a piling up of it. But I appreciate that members may not have had an opportunity to go through, and that is why it's not simply the confirmation of the minutes, but the reading of it, right? So we have to use the time expeditiously. All right, so do I have the concurrence of members?
Before we move forward, I was just seeking clarification on when you extended apologies on behalf of the leader of the opposition. And
no, I did not extend the apology. I simply noted for the record what was communicated to me by the committee clerk, that the members indicated that they would not attend today.
Oh, today?
Well, the procedure that we have in place is that a memorandum would be circulated reminding members of committees that the meeting will be held, and just for them to indicate whether they will or will not attend. So the memorandum was circulated in the House yesterday.
And I got an email in relation to this meeting. So
and it is this document that I was making a reference to.
And so, that just indicated would not attend?
Yes.
Okay.
Yes. But you may recall, as the minutes will show, that last week that member indicated his desire for answers to questions posed by him in a statement here. It would stand to reason that if this medium were used, then this medium would also be equally appropriate to provide the answers. Right. All right, so members concur with the request to defer items 5 and 6? Yes? Five and 6, the reading and confirmation of the minutes and matters arising, and we would proceed to the consideration of the content of the bill. Thank you. All right, the Ministry of Legal and Constitutional Affairs has prepared a presentation on the content of the bill for members of the committee and members of the public. Before we get to the presentation, I think I had omitted to have introduced and put on record members of the supporting technical team from the Ministry of Legal and Constitutional Affairs. So we will begin with the Permanent Secretary, Mr. Wayne Robertson.
Chairman, colleagues, all. My name is Wayne Robertson, Permanent Secretary in the Ministry.
The Permanent Secretary's
The role is the head of the Secretariat, which provides support to the Constitutional Reform Committee.
Thank you for adding that. Madam CPC.
Morning, members, colleagues. Judith Grant, Chief Parliamentary Counsel. Good morning, everyone. I am Crystal Paris Campbell, Assistant Parliamentary Counsel at the Office of the Parliamentary Counsel.
Good morning. My name is Philip Cross, Senior Constitutional Reform Officer at the Ministry.
Good morning, everyone. Christopher Harper, Senior Director, Constitutional Reform within the Ministry.
Good morning, everyone. Good morning, members. Janelle Miller-Williams, Senior Director of Legal Education.
Good morning, members. Sharika Mills, Constitutional Reform Officer.
Good morning, everyone. McKinney Brown. I am a legal officer within the Legal Reform Department.
Good morning, everybody. My name is Shauna K. Taylor-Reid. I'm the Administrative Assistant for the Constitutional Reform Division.
Good morning, everyone. I'm Nadine Wilkins, Director, Legal Reform Department in the Ministry of Legal and Constitutional Affairs.
Thank you so much. The presentation on the clauses of the bill will be made by Mr. Christopher Harper, our Senior Director in the Constitutional Reform Division of the Ministry.
Question? Just a question of interest. Am I looking at all lawyers on that side of the room? Is that a whole bag of lawyers over there? I just wonder.
Yes. I believe all but the admin assistant is legally trained, and all but the legal assistant and the permanent secretary are practicing attorneys, but the permanent secretary is also an LLB holder, but not a practicing lawyer. Well, as you know, Member Golden Campbell, the ministry is a technical ministry with a very technical and deep subject matter, so that it has to be staffed accordingly. There is another member from the ministry who is in the chamber, but in the top, and that's Ms. Brianna Russell. But we are assisting the staff of the Parliament with ensuring that the administrative matters are dealt with, and this is just because of our own experience that the paucity of resources sometimes have matters lagging behind. So from the ministry, we have worked out something to ensure that the work is kept on track and the Parliament is assisted. All right, I'm pleased to turn over to Chris to make the presentation. And those who are viewing online, I ask you to pay keen attention. Pardon me.
All right, so good morning once again, members. I have the honor of delivering a brief presentation and an overview, really, of the Constitution Amendment Republic Act 2024. The bill that is before members today, is a bill entitled An Act to Repeal the Jamaica Constitution Order in Council 1962 and to provide for the legal recognition and operation of the Constitution of Jamaica, notwithstanding the repeal of that order in council, to amend the Constitution of Jamaica to provide for a non-monarchical head of state, thereby establishing Jamaica as a republic, to make other amendments in respect of certain provisions of the Constitution, and to provide for connected matters. While this presentation does not intend to be a clause-by-clause, it does in fact highlight some of the key areas of change that are reflected in this bill. So my presentation will look at the Jamaicanization of the Constitution, the establishment of the Office of President, the expansion of the Senate, the modification of the alteration provision, which is Section 49 of the Constitution, enhancement to our existing citizenship provisions, which is contained within Chapter 2, alteration of the provisions related to qualification and disqualification from membership in the Parliament, and lastly, incorporation of the Electoral Commission of Jamaica.
Mr. Harper, may I
Slow down.
pray upon you to just speak a little slower?
Guided Minister and Chair. All right, so on the topic of Jamaicanization.
Just to say to members that we will go through the presentation and then we will take the interactive exchange. I think that may be more productive way to approach the matter.
All right, so on the topic of Jamaicanization, I would like to use this opportunity to invite members to consider the fact that the process of Jamaicanization is an ongoing one whereby the tabling of this bill and the changes proposed therein have signaled the official commencement of this process of Jamaicanization. It is therefore the hope that the process of Jamaicanization will culminate in the creation of a new constitution, a move which reinforces the importance and necessity of this phased approach. Accordingly, the bill gives effect to the Jamaicanization of the Constitution by doing three things. Firstly, it will seek to repeal the Jamaica Constitution Order in Council and provide for the legal recognition and operation of the Constitution of Jamaica. It also inserts a preamble, and it also incorporates our national symbols and emblems. I will take members of the committee through each aspect. So on the matter of the repealing of the Jamaica Constitution Order in Council, after 6 decades of sovereignty, it is no longer acceptable that Jamaica's constitution, although drafted in Jamaica and debated in the Parliament of Jamaica, should be contained in a schedule to a British imperial instrument, which we know to be the Jamaica Constitution Order in Council of 1962, which was made at the court at Buckingham Palace in England pursuant to the West Indies Act. As such, Clause 2 of the bill removes this imperial cloak by repealing the Jamaica Constitution Order in Council and providing that 1, the Constitution of Jamaica, as contained in the second schedule of the Order in Council, remains in force and is to be read and construed as one with the amendments set out in this bill. And it will also empower our statute law commissioners to publish the Constitution of Jamaica as an act comprised in Volume 1 of the Revised Laws of Jamaica. Now, in relation to the insertion of a preamble, Clause 3 of the bill in particular amends the Constitution by inserting a preamble which, in poetic and resonant tones, echo our heritage and proclaim the aspirations of the nation. Members, I'll use this opportunity to highlight that this preamble was proposed by a committee of experts comprising Professor Kwame Dawes, the 2025 to 2028 Poet Laureate, Dr. Joseph Farquharson, Senior Lecturer in the Department of Language, Linguistics and Philosophy at the University of the West Indies, Mr. Frankie Campbell, Manager of Show Band Fab Five and bassist, and Dr. Nadine Spence, Civil Society Representative on the Constitutional Reform Committee and Chairperson of the Expert Committee. The preamble itself is set out within the bill at Clause 3. Now, in continuing to examine how the bill Jamaicanizes our Constitution, it is also amended at Clause 34 to insert a new 4th schedule which incorporates the following national items. A, our national emblems inclusive of the Jamaican flag, our national anthem, and the coat of arms, our national symbols, which includes our national tree, our national flower, our national fruit, and our national bird, our national motto, national pledge, national song, and national prayer. So in these 3 proposed changes is how we the bill intends to Jamaicanize the Constitution as a starting point to the process. Now, in moving on, the bill also establishes the office of President, and the removal of the monarch as Jamaica's head of state prefaces a number of matters that has largely been consolidated into one, the establishment of the office of President with a Jamaican who meets certain criteria. Generally, the bill is structured to provide for different considerations in respect of the office of President, having regard to the replacement of the monarch who comes into office through succession. Accordingly, Clause 11 repeals some provisions of Chapter 4 of the Constitution in their entirety and replaces them with provisions in respect of the office of President. These provisions relate to qualifications for President, the procedure to appoint the President, the tenure of office of the President, which includes a procedure for resignation and removal of the President from office, and provisions related to immunity in the exercise of functions by the President. So in looking at the different subsections and sections within the bill as proposed, and in examining the qualifications of the President as outlined in the bill, the proposed section 24(2) at clause 11 provides that a person shall not be qualified to be appointed as a president unless that person is a citizen of Jamaica, whether by birth or descent. And I'll also use this opportunity to highlight that descent in this instance has been limited to 3 generations, which means that a nominee's entitlement to citizenship by descent would be derived from no further than a grandparent. The other qualifications for the office holder is that the President also has to be ordinarily resident in Jamaica for a period of at least 10 of 15 years immediately preceding the date of nomination, and is not disqualified for membership of the House of Representatives or the Senate. Now, in looking at the provisions related to the procedure for the appointment of the President, Section 25 at Clause 11 proposes that in appointing the President to office, there shall be a 2-stage process. 1, a process of nomination, and 2, a process of confirmation. Now, members, I'd also like to use this opportunity to invite you to note that there is, in fact, a variation between the recommendation as set out in the report of the Constitutional Reform Committee on the process of selecting the President and the method of selection proposed in the bill. This now is a direct response to feedback received from members of the public and other critical stakeholders. And furthermore, during the deliberations of the committee, this issue was one of most difficulty to navigate, and it was anticipated that there will be additional commentary on the selection process for the President as the conversation unfolds. But nevertheless, I would like to make it pellucidly clear that this matter is still open for further discussion. Now, in looking at the different processes that are before us, we have our nomination process as set out in the bill. And Section 25 of the bill provides that the Prime Minister is empowered to nominate a candidate for the office of President after a process of meaningful consultation with the Leader of the Opposition. The bill further stipulates that where the Prime Minister consults with the Leader of the Opposition, all reasonable steps must be taken by both parties to agree to the nomination. So, members, we have taken, we've tried our best to illustrate what this procedure looks like so that everyone can have an appreciation of how this process of reasonable steps to arrive at agreement will take place. So in looking at this flowchart that is being presented currently, it begins with the Prime Minister recommending a nominee to the Leader of the Opposition. If there is agreement, the Prime Minister must refer the nominee to Parliament for confirmation. If the Leader of the Opposition does not agree with the nominee proposed by the Prime Minister, the Prime Minister may do one of 2 things. He may, 1, refer the recommendation back to the Leader of the Opposition for reconsideration, or recommend a different nominee to the Leader of the Opposition. In the instance that the Prime Minister refers the recommendation back for reconsideration, the Leader of the Opposition may propose a different nominee. If there is agreement, the Prime Minister must refer that nominee to the Parliament for confirmation. However, if there is disagreement, the Prime Minister must, after a 3-month period, determine the nominee and refer the nominee to the Parliament. In the instance where the Prime Minister recommends a different nominee to the Leader of the Opposition, where there is agreement, the Prime Minister must refer the nominee to the Parliament for confirmation, and if there is disagreement, after a 3-month period, determine the nominee and refer the nominee to Parliament. This 3-month period referenced allows for a reasonable time frame within which both parties can consult on the matter before proceeding to Parliament for confirmation. Now, in looking at how the bill frames the confirmation process, the nominee for office of President is to be confirmed at a joint sitting of both Houses of Parliament, where each House would vote separately by secret ballot. The vote required to confirm the nominee is an absolute majority vote of all members. Now, I would also like to use this opportunity to highlight the fact that this is the first time that the bill will amend the Constitution to prescribe for a joint sitting of both Houses of the Parliament, as in previous instances that has been left to Constitutional Convention, where they sit at the opening of the Parliament for the receipt of the throne speech that is often delivered by the Governor-General. Now, in looking at the provisions related to the tenure of office, Section 26, subsection 1, proposes that the person appointed as president...
Please hold a minute.
I'm so sorry. But Chair, can I just ask, you're going still a little too fast for me, but can I just ask us to be mindful that the public is listening? So when we use terms like absolute majority, that we all know in here, can we just briefly explain what that means so that everyone listening can understand?
We will also come back to a deep dive into aspects of the presentation. So I'm just going to ask you to make a note of the questions that arise. I find that if we pause to explain, it may lengthen the presentation and also just impact the effect of the overview. But I appreciate the point you have made, and we indeed have flagged a number of things that we will come back to, beginning with the short title, for example, why Republic and not Republic of Jamaica. We will go through in detail with you. We spent a lot of time in the ministry doing this presentation because certainly I have a deep appreciation for the issues raised and just the general knowledge gap in the society and in the Parliament too. Chris, see if you can slow it down a little bit. Thank you. You know, Member Golden, I had taken the decision not to issue the presentation to members, to force members to actually listen, because I found, using myself as an example, flipping the presentation sometimes distract away the bill. Right. So even that pointing to the clause is specifically designed to direct members to make the note. Proceed.
All right, thank you. So, all right, on the matter of tenure of office, as I indicated earlier, the provision related to tenure of office is expansive to not only include the tenure itself, but provisions related to the resignation and removal from office. So Section 26, subsection 1, proposes that the person appointed as president shall hold office for a term of 7 years and is eligible to be reappointed for a further term not exceeding 5 years. The bill further stipulates that the question of reappointment should be determined within a period of 1 year immediately preceding the expiration of the person's first term as president. Now, this period of 1 year has been set to ensure that the selection process is not considered or pursued at the last minute, and that a reasonable time frame is allotted to allow for a process of meaningful consultation as highlighted in earlier provisions. Thank you. In relation to the removal from office, the CRC, in its report, was of the view that while it is necessary to provide the office of president with security of tenure so that it is not subject to the dictates of parliamentarians, it is equally necessary to provide a means of removing an incompetent, corrupt, or misbehaving president. Accordingly, the bill proposes at Section 26, subsection 5 in Clause 11, that at any time during the President's term of office, the President may be removed from office on any of the grounds specified in the bill. Now, these grounds for removal include where a President is unable to perform the functions of office, whether arising from an infirmity of mind or body, or from any other cause, where the President has behaved or is behaving in a manner that endangers the security of Jamaica, where the President has behaved or is behaving in a manner that brings the office of President into disrepute, or where the President, by his or her own act, is under a duty of allegiance, obedience, or adherence to a foreign power. Now, while we do recognize that there are a number of grounds upon which the President can be removed from office, the bill also sets out the procedure for removing the President from office. So the bill begins with where the question of whether the President should be removed from office on any of the grounds prescribed arises, a motion may be tabled by the leader of government business in the House at a joint sitting of both Houses of Parliament. It is to be noted that this motion must set out the grounds relied on, grounds relied on, the proposed members of the investigatory panel, including who will be designated chairperson, and the time within which that panel shall submit its report. Now, if the motion is carried by a 2/3 majority of all the members of each House of Parliament voting by secret ballot, an investigatory panel will be established to investigate the question of whether the President should be removed from office. This investigatory panel will consist of 3 members, being persons who hold, have held, or are qualified to hold office as judge of a court having unlimited jurisdiction in civil and criminal matters. Now, if the investigatory panel reports that any ground for removal has been made out to the satisfaction of that panel, Parliament shall vote by secret ballot at a joint sitting of both Houses of Parliament on the question of whether or not to remove the President from office. Now, where each House, by a 2/3 majority of all its members, votes that the President should be removed from office, the office will be deemed vacant and an interim President appointed until the vacancy is filled. Clause 11 also makes provision for immunity, and this is contained within Section 27, the proposed Section 27. And what it recognizes is that a person who holds office of President or exercises the functions of that office shall not be liable in any criminal or civil proceedings for any act done in respect of those functions, or while in office or exercising the functions of that office, any act not involving treason, violence, or fraud. Now, in proceeding with the presentation, we will now look at what changes have been made to the provisions related to the Senate. And as I would have indicated earlier, the bill proposes to expand the composition of the Senate. So the bill proposes that the Senate will be expanded to now include 15 senators appointed by the President, acting in accordance with the advice of the Prime Minister, 9 senators appointed by the President, acting in accordance with the advice of the Leader of the Opposition, and 3 senators appointed by the President, acting in his own discretion from among civil society, faith-based or community-based organizations, or other sectors of society, having regard to the representation by any such person of the interests of Jamaicans who reside abroad.
I think that has to be clarified, that in making the appointments, regard should be had to those persons being able to represent the interest of Jamaicans who reside overseas. Any of them, right? This is the proposed expansion of the Senate at clause
17.
Clause 17, which is the proposed section 35.
35.
Yes.
Also within the context of the expansion of the Senate, having regard to the inclusion of independent senators, the bill also proposes to restrict their ability to vote on constitutional matters in an effort to retain the parliamentary safeguard that requires the vote of at least one member of the opposition. This proposed formulation is set out at section 49, subsection 4, paragraph B, subparagraph 2 in clause 22, whereby a 2/3 majority vote requires the support of those members appointed on the advice of the Prime Minister and the Leader of the Opposition. All right, so now in looking at how the bill makes provision for the modification of the alteration provision, which is section 49 of the Constitution, clause 22 proposes to amend section 49 to reflect the following changes while maintaining the preeminence of the provision. Firstly, bills seeking to amend the Constitution must be introduced in the House of Representatives. Ordinarily, bills can be introduced in either, but for constitutional changes, those bills must be introduced, or it is proposed that these bills be introduced in the House of Representatives. As it relates to the interpretation provisions of the Constitution set out at section 2A and the Jamaican Interpretation Act, these are now entrenched in the same manner as those entrenched provisions prescribed at section 49, subsection 2, and 49, subsection 3 of the Constitution, to which they apply. Additionally, where a bill seeks to amend ordinary provisions of the Constitution, there is now a prescription of a 14-day period between the introduction of that bill in the House of Representatives and the commencement of the debate, and a further period of 14 days between the conclusion of that debate and the passage of the bill. Now, the insertion of these two 14-day periods will essentially remove the possibility of a bill seeking to reform ordinary provisions of the Constitution being tabled and passed in a single sitting of the House without due consideration of the provisions contained therein. The proposed time period will therefore provide parliamentarians with a 1-month opportunity to meaningfully review and consider the changes to the Constitution as set out in that bill. Another change to the alteration provision is that the periods between the introduction of the bill in the House of Representatives and the commencement of the debate and the conclusion of that debate and the passage of the bill in the House have been reduced from 3 months to 2 months for entrenched and deeply entrenched provisions as provided for at Section 49.2 and 49.3 respectively. The reduction in these time periods as proposed would increase the possibility and/or likelihood of legislative matters being dealt with within 1 legislative year, and this proposal also recalibrates the system to facilitate a faster pace of reform without compromising its purpose. Other proposed changes to Section 49, if a bill which alters...
Sorry, without compromising the safeguards.
The safeguard. Yes. If a bill which alters any safeguards, if the bill which alters any of the entrenched and deeply entrenched provisions of the Constitution is passed by the House of Representatives twice in the same session and having been sent to the Senate is rejected by the Senate, a reduction from 7 months to 4 months on the first occasion that the bill is sent to the Senate before the end of the session, and in two successive sessions, whether of the same Parliament or not, and having been sent to the Senate is rejected by the Senate, a reduction from 6 months to 4 months on the second occasion that the bill is sent to the Senate. Similarly, these proposed changes are geared towards ensuring efficient use of parliamentary time while maintaining the necessary safeguards. And the final proposed change to the alteration provision is that members should recall that the Constitution currently provides that any amendment to Section 49 requires the approval of the electorate. It is therefore being proposed that where a bill seeking to amend Section 49(2) of the Constitution, which outlines those provisions that are entrenched, contains only such alterations that add to or correct any reference made to such provisions, the bill shall be deemed to have been passed if it secures a 2/3 majority vote in both houses of Parliament only. This amendment therefore proposes to remove the need for a referendum to simply alter references to entrenched provisions, a change that will facilitate greater ease of reform to come.
Just to say, before getting into the discussion around what the provisions are intended to achieve, the proposed modification of the alteration mechanism in the Constitution is one of the most significant indication by the Holness administration of its seriousness to ensure that we can do the rest of the reform work. And it's important that everyone understands it, especially for those who believe that after this phase, nothing else will happen. Getting it done requires more than talk. And we have one of the most complex alteration mechanism in a constitution, in the Constitution of Jamaica. We will spend some time interrogating the proposal. But the two goals is to facilitate more efficient use of legislative time and to ensure that the appropriate safeguards remain. But we must get on with the work. Come back to that. Proceed.
All right, so the bill also seeks to enhance the existing citizenship framework as set out at Chapter 2 of the Constitution. And you would note that since Chapter 2 was amended, the citizenship provisions generally indicate how citizenship can be acquired and gives the state a discretionary power to grant citizenship to other people in certain specified circumstances, while granting the state the power to also deprive those persons of their citizenship. The changes therefore being pursued establishes a framework that can be achieved with greater clarity. As such, Clause 7 of the bill repeals and replaces Section 8 of the Constitution with a provision that A, retains the protection of Jamaicans who acquire citizenship by virtue of birth, descent, or marriage from being deprived of their Jamaican citizenship, and B, stipulates that a person who has been aggrieved by the deprivation of that person's Jamaican citizenship may also apply to the Supreme Court for redress. Now, Clause 8 of the bill repeals and replaces Sections 9 and 10 of the Constitution with provisions which prescribe that any person who is a citizen of Jamaica may renounce their Jamaican citizenship in accordance with the provisions of a law specifying the procedure for renunciation and sets out the powers of Parliament generally in relation to citizenship. Now, Clause 9 of the bill, which repeals and replaces Section 11 of the Constitution, empowers Parliament to make laws in respect of countries that are members of the Commonwealth and the Caribbean Community, otherwise known as CARICOM. And now, members, I want to invite you to appreciate the fact that for the first time in our history, the Caribbean Community has been given prominence in our constitutional framework. Now, in examining what changes are being proposed to those provisions related to qualification and disqualification from the membership in Parliament, Section 37, subsection 1, which provides for the qualifications of electors for elections to the House of Representatives, is amended at Clause 18 by restricting the qualification of electors to citizens of Jamaica resident in Jamaica at the date of registration who have attained the prescribed age only. Now, Section 39A, which stipulates the qualification for membership in the Senate and the House of Representatives, is amended at Clause 19 by prescribing that Jamaican citizenship rather than Commonwealth citizenship is essential qualifying citizenship criterion for membership in both houses of Parliament. And now Section 40, which indicates the circumstances in which a person may be disqualified from either house of the Parliament, is amended at Clause 20 by repealing subsections 2D and E and replacing it with a new provision that expands the circumstances listed to include convictions for fraud or violence, where the penalty for those offenses, or the penalty imposed rather, is a sentence of imprisonment for at least 18 months, and for treason.
This is particularly nuanced. It's a particularly nuanced provision. So it is having regard to the example of the gravity of the offense, because any offense can be exemplified in different levels of gravity. So you may have, and the sentence normally indicates that. So it's not just what the sentence is for the offense, but the sentence that is handed down after a conviction. We will come to that. And I think this is something that we will probably need to mainstream in our laws going forward. We'll come back to that. Exciting matters. And, you know, this is but a taste of why when we come to the judicial branch, we have to focus on it almost to the exclusion of anything else. We can't mix it up because the changes are so profound. Right? Proceed.
And the last substantive change to the framework dealing with the qualification and disqualification for membership in the Parliament is a proposed amendment to Section 41, which provides for the tenure of office of senators and members of the House of Representatives. This provision is amended at Clause 21 to stipulate that the seat of a member of either House shall become vacant if he or she ceases to be a Jamaican citizen rather than a Commonwealth citizen. And now on the matter of the incorporation of the Electoral Commission of Jamaica, which is the final set of major changes as proposed by this bill, Chapter 5 of the Constitution is amended at Clause 28, by incorporating or enshrining the ECJ, Electoral Commission of Jamaica, in the Constitution at Section 67A. This section provides for the establishment, objects, and functions of the ECJ and the power of Parliament to make laws in relation to the Constitution, staffing, and resources of the Commission and quorum at its meetings. Consequently, the Electoral Commission Interim Act will be amended to remove the words interim from the short title.
Among other things.
Among other things. And with that said,
This Electoral Commission section, then the only change you're saying is the inclusion in the Constitution. All of these provisions are consistent with the existing act as it is? Okay. Thank you.
Right. So the model is to provide for the ECJ as a constitutional commission and a commission of Parliament, and to allow enabling legislation, which is already in place, to deal with other matters. We have a model that has worked very well, so we're not really tinkering with it this time.
And members, that concludes my presentation. I thank you for your time, and I'll now hand over to the chair.
Thank you so much, Mr. Harper. Members, please join me in thanking Mr. Harper for a clear presentation. All right. Now, in reviewing this bill, it will be important for us to examine the provisions of the bill to ensure that the intention is clearly reflected in the words used. Our parliamentary culture is yet to attain this kind of discipline. And then when laws are interpreted as the text provides, quarrels break out, and we hear that what was intended is not what is there, and what is interpreted is a little different. We cannot afford to have these quarrels become bigger going forward. So legislators are being called upon to hone your skills and to understand very clearly what it means to be a member of Parliament, what your legislative role entails. Every bill is backed by a policy framework, and the policy has to be clearly articulated. It is from the policy that drafting instructions are prepared. And so, as we move forward for the new Jamaica that we have been dreaming about, we are doing this work in phases, not piecemeal. We already have the broad picture, and we know what the end product that we're seeking to achieve will look like. But so enormous and technical is the work, And so great is the knowledge gap in the society that we have to do it in digestible bits. Can't make the same mistakes going forward. So, members, all bills begin with a long title. And the long title tries as far as possible to tell you in concise form what the bill is seeking to achieve. And you would see from the long title, we are first of all repealing the imperial instrument. That's the Jamaica Constitution, Order in Council, 1962. And we are providing for the legal recognition and operation of the Constitution of Jamaica, which is contained in the schedule, the second schedule of this Imperial Order in Council. And we are providing for the legal recognition and operation of the Constitution, notwithstanding the decloaking. Right? So Mr. Harper, in his presentation, indicated that one of the goals being pursued is the Jamaicanization of the Constitution. That is not a one-off activity. It will be ongoing. But we're starting with the most symbolic and the most critical step by decloaking the Constitution that was made in Jamaica, debated in Jamaica, albeit within a colonial era and aided and assisted by the Colonial Office. But for those who are watching and are interested, I invite you to look at the records of the Parliament. If you need assistance in being facilitated, you can see the Hansard, you can see the records, which really correct a view that no work was done on the Constitution of Jamaica and it was simply dropped on us from England. Not so. All right? So that first part of the long title speaks to the goal of Jamaicanizing. It does not have everything, but it tells you the most important part. And then the second part of the long title tells you that we are amending the Constitution to provide for a non-monarchical head of state. And thereby we're establishing Jamaica as a republic. The nuance is that we are not establishing the Republic of Jamaica because our consultations reveal that Jamaicans are passionate about the name Jamaica. And no one wanted it to be changed to the Republic of Jamaica. So Jamaica becoming a republic will not change the name of the country. We are still Jamaica, land we love. Brand Jamaica, strong, punching above our weight. So it's important for you to understand that. And that is why the short title does not say Republic of Jamaica. It says Republic, which speaks to the form of government, but not the name of the state. The long title also speaks to the connected matters that have to be addressed in order to achieve the goals. So when we go to, well, let me pause and invite any comment from members. Member Davis?
The comment only as it relates to the name?
Any of it in relation to the long title, because this process also has to educate the people. So it's a joint select of a different flavor. Yes.
Well, I can appreciate the rationale for not changing the name, and I quite agree with it. Rather than being referred to as the Republic of Jamaica. As you rightly said, it changes the form of government, but still maintains our name.
Yes. You know, when you consider a name for a country or a change of name, you have to consider so many other things that involve cost and also identity. So even within the United Nations, within the foreign service operations, changing the embassies, all of the formalities that go through the international space, it would be a costly venture. But aside from that, Jamaicans who have made their voices and views known have said, Jamaica, this is a brand that we know and we will keep. So part of the approach is to keep what has worked for us, to strengthen, to move from good to better and to best. It's not about throwing out everything, because some things have worked for us, notwithstanding. All right? The bill also shows the new enacting clause. When Section 61 of the Constitution was amended for new words of enactment, it was a precursor step to the tabling of this bill, because the intention was to signal the seriousness that the laws to be passed by the Parliament of Jamaica and where necessary approved by the people of Jamaica will be done under the power of the people who elect their parliamentarians. So I don't know that everybody appreciated the significance of the change in the words of enactment, moving it out from the colonial monarchical term to simply be enacted by the Parliament, and in this case, the people of Jamaica. And the Parliament is tripartite, so the advice and consent of the Senate and the House of Representatives focuses on the two houses of the Parliament. And then in this case, it will require the approval of the people. And so this bill is to be enacted by the Parliament and the people. It will not get to the people unless the Senate and the House of Representatives consent to it by passing it. And so symbolically, it's important. Right? The presentation. So we then come to the short title, which is how it is cited. The Constitutional Amendment Republic Act, as I indicated, Republic and not Republic of Jamaica. It's also important for members to appreciate that there are provisions of this bill that will not be included in the reformed constitution. They will fall away. They make provision for. Perhaps I should ask the Chief Parliamentary Council to explain the difference with the bill and provisions that are for the bill itself, as opposed to provisions that are amending the Constitution.
Well, Madam Chair, usually the provisions that are amending the Constitution would be referred to as insertions or substitutions and would be included in quotation marks. The provisions that are part of this amending bill but would not form part of the amendment to the Constitution and therefore would not be incorporated in the Constitution would not contain those quotation marks, but they are part of this bill and will be passed as and recognized as law and have legal effect.
Thank you. Many do not understand because the time has never been taken to explain lawmaking process and the difference between an act of parliament and the actual law. So you may have many acts of parliament that relate to a single law. They come in many amending acts. So you have a principal act and you have amending acts. And then there is a law revision process that is required to consolidate the law, to enable users of the law to find all the provisions in relation to the particular law, statute law, in one place. Or economic affairs have caused decisions to be taken that have really done an injustice to the legal infrastructure of the country. So this ministry also has responsibility for the entire state of the laws. And since its establishment, we have been working assiduously to do the stock-taking of the law. The Director of Legal Reform, Ms. Wilkins, can tell you that when money was not available, some decisions were taken to shortcut the process. And the shortcutting of the process is showing up now in the impaired capacity of the state to enforce the law and to implement the law, because many people don't even know where to find all of the laws. Ms. Wilkins?
Thank you, Chair. That is an accurate statement. Unfortunately, other countries take this exercise very seriously. So a law is passed, it is subsequently amended many times, and each time consolidation is done with alacrity, and its availability in its consolidated form is there within a short time. So we don't end up with a situation where a judge is taking a decision in a court on a provision which was amended, simply because the current position was not available, readily available. So it is indeed a serious matter.
Members, this work that has culminated in the bill is a lot more than what has been reduced in the bill. The Wholeness Administration has approached the relaying of the foundation of the nation very seriously. And, you know, humorously it was asked whether the members of the technical team are lawyers alone. The work is technical and it requires deep expertise, which we are building out in a young team. But make no mistake, it may not be the fluffy kind of thing that attracts attention. But we do know the impact of it when people's cry for justice are being made across the length and breadth of the nation. It comes right back to this work. So, long title, enacting clause, short title. That takes us to the first clause of the bill. And the clause 1 has 2 subclauses. The second speaks to when the bill will come into operation, and that is the appointed day. There are different methods by which a law passed can come into operation. It can be done automatically once the procedural steps are complied with, including the gazetting, and it can also be appointed for a specific date. Now, because of the number of things that we're seeking to do and the significance of the symbolism, we are using an appointed day, so we have control on when the law comes into effect. And we will give some consideration to how it relates to our current Independence Day or current Emancipation Day. So it is deliberate. Any comment or question?
Thank you, Madam Chair. Through you to the Chief Parliamentary Council. When we use the appointed day provision, how in the context of the requirements for the
assent?
The sitting of the bill, my words are escaping me. The requirement in passing constitutional bill like this, for it to sit, the debate, and then sit again, does that affect, if we are using an appointed day, does that affect the timelines for those things? In other words, when it's passed, it's not yet in effect. Is it 3 months running at that time?
Those periods that are referenced have to do with the procedure for an enactment. So the coming into operation is a separate thing. What this appointed day provision does is delay even though the bill would have been enacted in accordance with the provision, including the timelines, it would delay the operation until the date has been appointed.
Thank you. All right. So we then go to Clause 2 of the bill. Clause 2 repeals the order in council and saves the Constitution. It is made subject to the provisions of the clause, the provisions of the section, because they have to be read together and understood together in a composite way. So the order in council is repealed, just to say that the power of the Parliament to repeal this instrument is set out in the Constitution itself. But in order for the Parliament to exercise that power, it has to activate the mechanism for deep entrenchment, because this is part of the constitutional documents and they are protected at Section 49. So this can only be done through the deeply entrenched mechanism, which ultimately requires the approval of the people. So you will realize as we go through the bill that some of the provisions could be passed by using the ordinary amendment procedure. Some could be passed using the entrenched amendment procedure. And some, the majority, require the deeply amendment procedure. Because we are using the opportunity to achieve this first goal of Jamaicanizing, or reading of the guidance that we get on the procedure is that it is okay to do it together. But it would have been also okay if we were doing it in a piecemeal way, which is what we are accused of, but that's a false accusation. It could have been done little bits and pieces, but the goals are very clear that we're seeking to achieve. And we have had the benefit of guidance on how the alteration mechanism is to work. And we have paid very close attention to that guidance. All right, so Clause 2, firstly, revokes the order and then provides for the continuation in force of the Constitution, which would be read and construed with the amendments made. And then the statute law commissioners are being empowered to publish the Constitution as an act comprising Volume 1 of the revised laws. Initially, we had contemplated making the Constitution itself all of Volume 1. But because of the other work that the ministry is tasked with and the revision that is required, Volume 1 will have all of the constitutional documents, not just the Constitution itself. The Jamaica Independence Act will also go here. Any regulations that relate directly to the Constitution will also go in Volume 1. Ms. Wilkins, is that an accurate?
Well, they're in the subsidiary legislation now in those volumes. It may not be possible to move it to the statutes. That may be a little tricky. I can't say for sure that we can.
Well, not everything.
No.
But the intention is to have Volume 1 having our constitutional instruments. Madam CPC?
Yes, so it would be the instruments that constitute principal legislation, which are acts. So we're talking about the also including the Interpretation Act for ease of reference, since that applies now, would apply to the interpretation of the Constitution as well.
Right, so just to make it clear, it's not just the Constitution, and it would be the primary legislation. I think what was omitted from the presentation is that the Jamaicanization also includes the use of the Jamaica Interpretation Act, as opposed to the frozen 1889 UK Interpretation Act. Right? Yes.
I think I'm going to ask the questions that I think ordinary Jamaicans would like answers to, because while I comprehend what is being said, we are using a lot of jargon. So would the CPC be kind enough to advise the country what is the Interpretation Act?
So the Interpretation Act is an act of Parliament that governs how we would interpret some terms that are used throughout legislation in Jamaica. So wherever you have a term that is defined in the Interpretation Act and it's used in an act, unless the act provides otherwise, that term as defined in the Interpretation Act would apply to the definition of the word used, unless another definition is provided specifically in the act. So currently, though, there is a sort of disassociation between the Interpretation Act that we have now, because that governs all our acts except the Constitution. The interpretation of the Constitution currently is governed by the UK Interpretation Act. So this provision, part of the Jamaicanizing, would be to apply our Interpretation Act to the Constitution.
So would that mean then, Madam Chair, that we would be seeking to make some amendments to the Interpretation Act, and that would happen? That would be part of the consequential work that you're going to engage. There's a copy here. I'm so sorry.
It's currently in this bill, right. But yes, there would be a further review of the Interpretation Act.
Okay, thank you so much.
As a follow-up, if you look at page 48 of the bill, you would see the Interpretation Act set out there as one of the acts being consequentially amended. Mm-hmm. But it's important for everyone to note that this is just the beginning of the process.
Right.
The work is a lot. It cannot all be done at once.
And just a further question. In consolidating the constitutional documents in Volume 1, what I understood you to say is you would have your Constitution, and any acts that relate to your Constitution relate specifically to the Constitution. But you're also seeking to include regulations that come from those?
Not quite yet.
No? Okay.
Because how our laws are published, you have the Acts of Parliament, which are the principal legislation. that are published separately from the subsidiary legislation, meaning these are the laws that are passed through the delegated power to other entities, the ministers, is for the public. Right. So one of the conversations that we're having in the ministry that we have already begun is how we publish the law. Speaking for myself, and in particular, when I sat on the bench, I found it annoying that all provisions in relation to a law were not in the same place. I'm talking about user friendliness. Some jurisdictions do it differently. So you can see regulations alongside the act itself. You can see the orders, the notices. If we had maintained the discipline, or if we hadn't lost our way, we would be in a better place for people to know exactly what is required, what is the standard of behavior that is set in the law, and how you're enforcing it generally.
Just so I understand, are you talking about just how it's captured in the volumes?
How we publish them. How we publish them. Because remember now, public promulgation of law is one of the planks of rule of law. So right now, the laws, matters related to one piece of legislation is all over the place. And if an important aspect is done, say, by a minister, by order, and that is not subject to affirmative resolution, which means it doesn't have to come to the parliament to be approved, then it may be somewhere hidden, though it's required to be gazetted in order for it to have the effect of law. For those who are listening, the real point is that the work to put Jamaica's legal infrastructure in place is a lot of work. But it is important if we are going to move to getting the level of public order that is required, if we're going to move from a culture of impunity to accountability, this is critical work. And the Prime Minister Holness has made it clear that this is something that must be done, because season after season, people are asking for accountability in government, accountability in the society. But the truth is that many still need to know what is the standard.
So, okay, so when you're talking about publishing then,
yes,
how we publish.
If you look right in front of you.
Yeah, but so those are, I get that, but I can safely say, I would put my head, maybe not my neck, on the block to say that nobody, the age of my children, and the eldest is 17, is going to read any one of those books. So how we publish, is it such an issue now, given that our publication mechanism is really through electronic means? And how would you capture, in looking at this particular clause 2, how would you capture that intent to put all the laws in one place through that electronic means?
All right, I'm going to give you some insight on the work that we're doing, which every year since the ministry has been established, I've spoken about in the Parliament with our portal that we're working on. But just to say that while it is important for all Jamaicans to read and understand the law, the truth is that using the laws also require special training. And I don't want this point to be misunderstood. We don't become lawyers overnight. We don't become judges overnight. That is not to say that we should not ensure that the ordinary man can understand. But the truth is that for some matters, people have to be advised and counseled. So part of the work of government is also to break it down simply In respect of the provision at clause 2, subclause 3, it's really just indicating a shift that will take place, that the Constitution will become Volume 1 as an indication that it is the number one law of the land, first and foremost, and alongside it we will include the other matters that are the constitutional instruments. So 2 immediately would be the Jamaica Independence Act, and the other one would be the Interpretation Act. All right? And then when we come to the subsidiary legislation over time, when we revise, they will perhaps mirror the primary laws of Parliament. So your first volume of your subsidiary legislation will have the regulations relating to the Constitution. Yes. And in that, eventually, will also be placed the standing orders of the houses, because these are regulations of the Constitution.
You inspired a question in that about the way we draft our laws. And as a practitioner in the commercial area, contracts are things we look at every day. Is there anything ought there to be, let me frame it that way, something in our constitutional bill that speaks to a method of drafting our laws in language plain and as simple as necessary for our people to understand? And I'm going to just contextualize that a little bit. Quite often when we look at legislation, we still, even in the 2000s, use Latin phrases. Things like mutatis mutandis, that's a favorite one. I don't know of this parliamentary council, but because I know how she drafts, but we have used it in the past. So let me just say that. But I would love to see us have some commitment that is a firm one and not one that moves by the decision of the drafter or the minister, that when we write our laws and amend our laws, that we will do it in the most modern, easily understandable language. I do not use Old English in contract writing anymore. I can't tell you that it is easier, but it's certainly far easier for my clients to understand what the provisions of the agreements are. So my wish would be that they're in the process of the reform, that we make that commitment to the people of Jamaica, that when we write the law, we're going to do it in a way that they can understand it. Accepting, of course, that you still need advocates sometimes to interpret and to assist you with problems that you have to apply the law to.
You have raised a lot of issues. So the simple answer is that every effort is being made to ensure that our laws are written in clear and easy language. And I think we have good examples. Even recently, when the Income Tax Act was being amended, the opportunity was used to tidy up some provisions. But bear in mind that laws also deal with technical matters that have to be reflected in the technical way. And what we have to do is to bring up the society with the level of education and understanding so they can better relate. I think the knowledge gap in the society has been a greater determinant of people's inability to interact with the laws. if you look on some of the very old laws passed during the colonial era, some of them are written in clear language, only that the sentences are too long. So you have many clauses, yes, right? But when you break them down, the simple language, I'm going to ask the CPC to weigh in on it. But let me also answer you that no, you do not make a provision like that in your constitution. The constitution is not the place to direct your chief parliamentary council to write your laws in clear language. Bear in mind, no, your constitution has broad principles, not administrative mechanics. Hold on. Remember, though, that after a draft is produced, it is the parliamentarians who pass the laws. And very often, the work to review the clause of the bill to say, hold on, this clause is too technically written, is not done by the parliament. So with all due respect, that work does not reside in the CPC alone, the solution. The way laws are passed is that every minister has responsibility for subject matters. Government of Jamaica is arranged in ministries, departments, and agencies, and each ministry is given a portfolio of matters. That's why you talk about the portfolio minister. And that portfolio includes subject matters and the laws that relate to those subject matters. Hold on. No, I haven't gone wide. I'm telling you that the work to ensure that the laws coming to the parliament are written in as clear a language as possible must be done outside of the parliament as well as inside of the parliament. And the constitution is not the place to say that a drafter must draft in clear language. I see. Well, pose it again, because I wrote it down, whether there should be a provision in the Constitution about how we draft the law. That was what I wrote down when you asked.
And I am not suggesting I did not say that, but let me clarify what I really mean. Right. It's not so much to direct the mechanics of the drafting, is to say in our Constitution that the commitment we have to our people is that we provide laws as best as possible, as whatever the language is. I'm not trying to write it. I'm simply saying a commitment that our laws are set out in a way that it's easiest for people to understand. There is I have heard it many times. I have experienced it many times as a lawyer trained in legislative law, that you have to read it over and over again to get it. Some of the older laws, of course, with the 2-page provisions, one provision spanning 2 pages, and the colons and the semicolons and so on. The average person is not going to understand that. And I'm simply saying in this reform process, if there is some commitment that we can make to the people of Jamaica, that when we ask them to abide by laws, we're going to set it out in a way that's most easy for them to understand. And if it can't be done in the Constitution, 1, tell me why, and 2, tell me where we make that commitment to the people of Jamaica.
You want to?
I would only add that we at OPC have for some...
The OPC is the Office of the Parliamentary Council, for those who are listening.
Right, thank you, Chair. We have been committed to using plain language. It has been a movement not only here, but internationally among drafters. But you'll find that it might not be obvious, and it's constrained by several things. One of which is many times what we're doing is amending laws, and we have to be true to the text. So you find that we can't really depart from the language too much because there will be inconsistencies. But insofar as we do new legislation, we do try to use as simple language as possible. Again, constraints because Some of them deal with technical issues. And again, we are creatures of instructions, so you'll find we might set out something in what we think is the clearest, plainest way, but when it goes for review and you have stakeholder comments, there's a level of complexity that is then added to what we have provided. But then I would suggest that maybe the way of approaching it is not really maybe to have something setting out that requiring us to draft in as plain language as possible, since we have committed to that. But maybe we could look to employing other mechanisms, such as including explanatory memoranda, which would accompany acts as a feature of legislation.
And just to say, already the ministry is doing that. We have already begun. Even in the work of the reform, after the report was done, published as a ministry paper to ensure that it becomes part of the catalogue of the Parliament for access. We have published in different places. We have done, broken it down into simple, easy language. But remember that the extent to which people understand things will also be a function of their own level of education and their willingness to be guided. There are a lot of variables, but be assured that the Ministry of Legal and Constitutional Affairs is paying very close attention.
The explanatory notes you're talking about, Minister.
Yes.
So those are now going to be a part of our acts, when our acts, how does that work?
We are looking at it.
Or are you talking about publishing separate documents on an act?
Both. Okay. Because I think the work to, the work to get Jamaica as a society to operate lawfully is a lot of work. And first of all, people have to understand the standard of conduct that is required, the agreed conduct, what it is that will bind all of us. So, for example, we agree that you don't steal people things. You don't take what don't belong to you. Or if we use another example, meaning that when you pass laws, you're legislating what should be the appropriate conduct as a community, as a whole. The CPC said part of the problem is that we have not done the comprehensive revision of the laws that should happen. So laws usually have their own internal scheme for internal coherence. This constitution, for example, is so interrelated. The parts and provisions are so interrelated that if you tinker with one provision without understanding its impact on another provision, you can run into trouble. And that trouble will come up when a case is litigated in the court. And then you see it unfold. But long answer, short answer is the commitment is there. The work has already begun.
I thank you for that. And I just share with you, on my last visit to the House of Commons, one of the things that I observed, of course, were the documents put out by the Secretariat in the Commons, I think really particularly in the library, which were sort of explanatory documents on the provisions, I can't remember what they call them now, explanatory documents on the provisions of bills being considered as well as acts when they passed, assuming they had amendments and so on. So maybe I'm probably misdirecting my question because it may not be a ministry function. It may actually be a parliamentary function.
So
I look forward, let me just say this for the plug for it, I look forward to our new parliament where we will have that kind of capacity in the parliament so that people can really interact with the lawmaking process.
Member Kerencia Morrison wanted to weigh in, but just before she comes in, the reference to the statute law commissioners at clause 2, subclause 3, really also references the work of law revision under the Law Revision Act. And an amendment is going to be coming hopefully before, I'm giving the side eye to the director of, the PS is interrupting because he's extending the timeline I have given them. one of the revisions that is being proposed is to formally have the clerk to the Houses of Parliament on the Law Revision Commission. Believe it or not, Member Golding, it is as puzzling to me that it is not formally in place. So if you look on the legislative priorities published for the Ministry of Legal and Constitutional Affairs, listed among them was an amendment to the Law Revision Act. We had our last meeting last week, right, and we have been meeting periodically, recently, as we bring the pieces together. This is what excites me. I mean, so much is happening. Member Morrison.
Thank you, Chair. Even though the discourse had progressed somewhat, and I don't like really taking a few steps back, especially if I figure that some sufficient response was made. But since I have been identified, I just want to note that there are areas of particular interest that Jamaicans are listening for. And so, Member Golding, I find your intervention to be very useful, and so we will have to pay particular attention to how we retail what happens here, right, to the ordinary Jamaicans who may not understand the legal language. Myself could be probably included in that. So at some point we may have to have a robust public education and to see the extent to which we could include even our justices of the peace who interact a lot with members of the community who will help to broker what takes place here on this very critical piece of work to the average person in our community who may need to have clarity, right, on these matters. Because even though we are not here, Chair, pardon me, I am going to mention this section about qualification and disqualification for members, for membership in the Parliament. We are not here, but I just want to strengthen the point that I'm making. Section 39 of the Constitution, I have been harassing my colleague here to assist me with interpretation. Section 39 of the Constitution speaks very clearly about what qualifies a Jamaican to sit as Member of Parliament, but I'm now, based on the excellent breakdown, interpretation that is being given here, the qualification and disqualification for members in the Parliament, we find Jamaicans from time to time who want to offer themselves to serve as members of Parliament. There's a debate that often that comes to the fore. Varying interpretation of Section 40 of the Constitution as it pertains persons who are eligible and ineligible to offer themselves as members of Parliament. What if someone is convicted and served time? Can that person offer themselves to run as MP? If the record was expunged, we get a lot of that. The record was expunged how many years ago? Can we now offer ourselves to run as MP? And just by listening to the deliberation, I wrote down a question. If the Member of Parliament, having been disqualified, right, by virtue of conviction, etc., having served the time, can that person reoffer themselves to run as MP? So, Member Golding, I am finding your intervention to be very useful in terms of what the Jamaican public is listening to hear very clearly. So this is beyond the French or the Italian language now, but basically when the ordinary Jamaicans say, in can run for MP or in can't run for MP, we want to hear it broken down in very clear, simple, and relatable language. That's one of the things that I would love to see coming out. And thank you, Member, for your legal counsel around here.
You're the only non-lawyer in the committee. What a good thing, because you bring a fresh and different perspective on the matter. I think the point is well made, and it is something that came up a lot in our consultations with the public. Madam Director, Legal Education, you want to weigh in and just to share some of the work that you are doing in your interaction within government and also with the public?
Okay, thank you for that, Chair.
Please state your name for the
Yes,
Hansard.
I am Janelle Miller Williams, right, Senior Director of Legal Education. So in terms of the intention, we have an intention of going out there more in the public, and we have done so far, right? So we have gone into the public sector, going into the ministries, departments, and agencies. We have gone into the private sector as well, and we continue to do so. We're weighing in on tertiary institutions, secondary institutions, churches, also even going into the various communities, right? So we go into the communities and just have a conversation with various persons, with the layman. Also, we intend on having webinars and recorded lectures, right? And also clubs, various clubs, you know. Particularly, we also intend on having broadcasting in the radio and the television as well to reach to, you know, a wider cross-section of persons, and certainly through social media that can reach a wider cross-section of persons within a short space of time. So we do have that program, and we certainly, you know, are ready and prepared to start, you know, educating on the bill. But so far we have, you know, we have been going out there educating to these various entities on the recommendations of the Constitutional Reform Committee, but now we are going out to educate on the contents of the bill.
We will eventually have to come down to the PD level because of the constitutional provision that the people who vote for members of parliament will have to vote to approve the bill. So even as we get into the campaign season, we will be coming into your constituencies and in your divisions and in your PDs to host meetings around the importance of this work. So you will see us. It's a lot of work that is ahead of us. So, Kerencia, Member Morrison, I know, for example, you have a large rural base, as does Member Davis. And if I use my constituency as an example, there is hardly an occasion that I go out without people asking me something about the constitutional reform. And in one of my community groups, and some of them may be tuned in, there is the Irwin Community Group. That is a community group that debates policy issues heavily. So from last week, when we began, they were already exchanging perspectives on what they saw, what their views were on the presentations made. So believe it or not, the conversations are taking place on the ground. And some of the issues are so novel. The one about nationality is one that has sparked a lot of interest. And I think particularly because they are identifying the issue with actual members. They're identifying the Commonwealth citizenship and the Jamaican citizenship. They have brought back the question of those who held US citizenship and matters going to court. So when the Constitution lifts off the pages and walks into their spaces because of how things have played out, believe me, a lot of questions are asked. There's hardly a day that I go out in my seat that I don't have to spend some time. Well, their own curiosity about what their member of parliament is leading is part of it too. So that's it in respect of the clause. Clause 2. You will see at clause 2.4 that we have to preserve the privileges of those who have Jamaican citizenship by virtue of the existing order in council and the older provisions of the Constitution that we are changing, because we will get to another stage of the reform when we can look holistically. The safe approach is to ensure that these changes have no detrimental impact on others. Senator Sinclair, I know you appreciate, well, you can make your comment.
I read it before you actually got to it, and the same comments that you're making is what would have crossed my mind. We have to preserve what persons would have expected from the existing circumstance, and that we don't create a situation that leads to detriment for those persons.
Yes.
And in fact, I have a personal situation that would have not necessarily fitted into this, but can be impacted by it at some point.
So you fully understand the importance of the provision, I see. Very well. All right. So that, so members, Clause 2 speaks to the most consequential technical aspect of the Jamaicanizing of it, of the Constitution, and the putting the Constitution in proper form, taking it from under the cloak of the Order in Council, the Imperial Order in Council, and having it published as the #1 law of Jamaica. When we go to Clause 3, that's another aspect of the Jamaicanization. The international observers who were on the island, my constitution, on the island 2 weeks ago, I found it hilarious when they were pointing to the proposed preamble. And they did that in contrast with what are the opening words to the Constitution now. So what you see existing, no, let me find it, is at the court at Buckingham Palace, the 23rd day of July, 1962, presents the Queen's Most Excellent Majesty in Council, Her Majesty, by virtue and in exercise of the powers in that behalf, by subsection 1 of section 5 of the West Indies Act, 1962, or otherwise in her vested, is pleased by and with the advice of her Privy Council to order, and it is hereby ordered as follows. Compare now what is being proposed as your opening words. We, the people of Jamaica, affirm our place as a free and self-respecting people in the global community. We proudly acknowledge that our history of struggle, sacrifice, endurance, and triumph led us to become an independent democratic nation. We resoundingly acclaim this heritage and hold it in trust to pass on to future generations. We joyfully celebrate our resilient spirit in the face of adversity, our outstanding achievements in different fields, and our contribution to the advancement of humanity. We humbly proclaim our gratitude to the Almighty for the beauty of our island, the abundance of our natural resources, our talents, and the strong institutions we have built. We wholeheartedly commit to the protection and preservation of our culture and environment, to the principles of justice, equity, and truth, to the upholding of the rights of all, and the enhancement of our moral, material, and spiritual well-being, to which end we solemnly declare this Constitution to be the sovereign will of the people of Jamaica. Yes, Member Davis?
Thank you, Chair. As you were reading, I thought we should be standing at attention.
But look at the difference. It's the shift from the power of a hereditary monarch to the power of the people. Bringing together the journey we have taken, an appreciation for where we are, and the aspirations before us.
Madam Chair, I don't preamble, it may be called, which, you know, those words, preamble, sound close to ramble. But I must tell you, the significance of this preamble cannot be understated. And I see very clearly in my mind the impact it can have when children get up in a class, in a primary school, and recite the preamble, use the words that you have just read to us a while ago. One of the things I noted when I went to law school in the United States was that most everybody, Americans, who were in my class could tell you their Bill of Rights, the 10 Bill of Rights. First one, Congress shall make no law. That's the only one, that's the only part of it that I remember by heart. And I always envied the closeness they felt to their Constitution. They were taught it in high school. High school had a mandatory government. I think that was the name of the class. Or equivalent to that would be civics. I don't know if we teach our Constitution in our civics lessons. I've never seen it. I know I heard Minister Grange affirming in the Parliament recently that civics was being taught in the primary levels, high school levels, and so on. I don't know what the curriculum actually is. But I just want to support you in affirming the importance of these words. We the people of Jamaica, we the people who have come from, have endured, and are moving forward together. I'm getting goosebumps. I got goosebumps as you were reading it because it is empowering. It lands us squarely in our country. It gives us an ownership, a sense of ownership that we struggle with because so many of us still are seeking a visa, a green card, some other passport to be able to go away, not understanding where we have been, where we are coming from, and where we are going. So on the days subsequent to the pardoning of the Right Honorable Marcus Mosiah Garvey by the outgoing President of the United States, these words are really chilling. They are really empowering. They're powerful. And I hope that in the education campaign, much attention will be given to sharing these words as we educate about the more technical provisions of the Constitution. I think these are words that the Right Honorable Marcus Mosiah Garvey would have been happy to see in our Jamaican Constitution.
I believe that Garveyism should be taught in Jamaica. I don't think we fully understand the contribution that a Jamaican has made to a life philosophy, a way of ordering nation, black people. Member Morrison?
Thank you, Chair. Again, in support of Member Golding, this preamble has the potential to run parallel to our national pledge. It is that strong. And so the reading of it, the initial reading, in my mind, it captured images of this lovely English lady with tea or in a ball setting. But this one conjures up fierce pride, patriotism, nationalism. So a reading of it ought not to be soulful, but one that is driven, one that is purposeful, because we are recentering in the minds of our young people, even many of them who seem to be losing their way, and many who don't understand what it means to be a Jamaican. We are recentering in their mind patriotism, nationalism. It's a part of our identity. So it's not, we won't say we the people, it's we the people of Jamaica.
I won't be as long, but when you went through it, and myself reading through it, certain things, just single words came up. History, pride, emotions, inspiration. It had a lot of it inspired me. What I found most significant is when I look on the words, we wholeheartedly commit to the protection and preservation of our culture and environment, to the principles of justice, equity, and truth, to the upholding of the rights of all, and to enhance the enhancement of our moral, material, and spiritual well-being. Is this particular preamble speaking to the responsibility of us as Jamaicans? And in fact, I'm in the process of just of preparing a presentation that I have to do next week, Tuesday in Westmoreland. And I highlighted the preamble of the existing constitution, the Charter of Rights, because every day Jamaicans get up, that they have the right to the right to the right to the right to. But no one focuses on that preamble, let us see, which speaks to their responsibility. And putting it where it is, at clause 3, and having it stated early in the day that we have a responsibility to commit ourselves to these particular goals is something that I find very interesting. And as you have rightly said, the relaunch of civics, not as a part of a subject called social studies. But when I was at school in the early stages of my life, where I was taught civics, the responsibility of me as a citizen of Jamaica is something that I believe that we have to get back to.
Thank you, colleagues. Just to say that some critics have raised the issue of the extent of the people's participation in this process. Chris, can you just repeat and remind that the settling of this preamble went through a process that involved the people, representatives of the people, who would take into account all that needed to be accounted for. Just to remind, and let me use the opportunity to repeat my thank you to that committee. And we pulled from Jamaicans who are in touch with the pulse of the nation. We gave them the drafts, because I too prepared a draft, which is significantly incorporated here. Dr. Barnett prepared it, and we had the previous drafts that were done at independence and since then. But please repeat so we can again say thank you to the members of the committee.
So the members who comprise the committee of experts who presented this wonderful preamble would have been Professor Kwame Dawes, the 2025-2028 Poet Laureate, Dr. Joseph Farquharson, Senior Lecturer in the Department of Language, Linguistics and Philosophy at the University of the West Indies, Mr. Frankie Campbell, Manager of show band Fab 5 and bassist, and Dr. Nadine Spence, who is a civil society rep on the Constitutional Reform Committee. And if I may, Chair, add, this is building on the work of the preambles that were considered by previous commissions and joint select committees in relation to this constitutional process, including Professor Edward Barr, Honorable David Core, QC, KC, Jeffrey Mordecai, Attorney at Law, Senator Ryan Peralto, the Honorable Sir Philip Sherlock, OJ, and as Chair indicated, Dr. Barnett, herself, as chairman of the committee, and we even received submission from members of the public, Mr. Randolph Rossi, who would have submitted to the Secretariat and was considered in this process.
So contrary to a perspective being peddled, that the work has shut out the people, not so, not so. Government is not administered by the man in the street, you know, but we have taken great care to also build on the work done previously, because before some of us were born, I don't think any of us, I don't know for Senator Sinclair, right? But right? Part of the approach of this administration is to honor the contribution of those who have gone before, in the same way that we hope that others who come behind us will find us faithful. But Senator Member Morrison, because I know of your talent, I was thinking, PS, that maybe we could recruit Senator Morrison to do a voicing of the preamble for us as part of our public education, because she has special talent since she's a member of the Joint Select Committee. I think we will get many versions of it. She's quite versatile as a former teacher, an English teacher, yes. But I don't mean to lay hands suddenly on you, but because the constitutional reform mechanism involves the people, getting to the people, the same ones who vote for us, you and me, and Member Tamika Davis. We have to get it to them. And so there is no dispute about the need for the education, and this is one that I hope you will accept my invitation to voice something for us. All right? All right, so we probably could jump over to looking at the fourth schedule, which has the national items that are being included. Because I know there is a lot of debate on, for example, the coat of arms. The current form of the coat of arms. So since we're dealing with the first goal of Jamaicanizing, we have looked at the revocation of the imperial instrument, the Jamaica Constitution Order in Council 1962, the continuation in force of the Constitution to be read and construed as one with the amendments made, the direction to the Statute Law Commissioners to publish it as number one, representing the number one law, the saving of the privileges and benefits of those who would have achieved the status of citizens of Jamaica immediately before the revocation of the imperial instrument and the inclusion of the preamble, we can jump now to another part of the Jamaicanizing. Let me say, based on some questions asked in some places, Madam CPC, can you just indicate that what alteration provisions would be activated to deal with items in the schedule, just to address issues for those who are wondering if and when other aspects of the revision is done and changes may need to be made, for example, to the coat of arms, the ease with which that can be done. It's an ordinary provision, but please explain that.
So it would be the amended procedure proposed here for the ordinary provisions, which would mean a bill would be introduced in the House of Representatives, and a period of 14 days would have to elapse between when the bill is introduced and when the first debate is held, and then a further period of 14 days from the conclusion of the debate till when the bill is passed.
And it would be passed within the Parliament with the absolute majority. All right? Absolute majority means the majority of the total number of the members of the House. It's different from a simple majority, which is the majority of the members present and voting. So the House comprises 63 members. The absolute majority is, Senator Sinclair? Absolute majority, 32. 63, 32, right. Not the 2/3 majority, no. So in some cases, when members of the public are looking on, they may see an empty house. As long as you have a quorum, you can take the vote for ordinary legislation on the majority of those who are present. Anything having to do with the Constitution, you need the majority of the total number of the House. Cannot go beneath the absolute majority. That's a big difference, because your Constitution as your highest law is protected in many ways. So even the easiest provisions to change require the presence of the majority of the members of each House of Parliament, not just the majority of those who are present at the time. All right? Majority of the number, the absolute number, the majority of the 63, the majority of the 21, not the majority of those who are here. So, for example, you have a quorum, and the majority of the quorum here, but we have a number of the composition of the joint select, the 15, right? Just by way of example. There's a difference between a simple majority and an absolute majority. And after all, that's the level of respect that must be shown to your highest law. So let's jump over. You were saying, Senator Sinclair, that the preamble can go alongside the pledge. The pledge will become part of the Constitution. And again, I don't recall now who penned the words, but what an inspiration. It speaks aspirationally. It combines your sense of duty, your rights and responsibility. And I'd say to all of you that the National Pledge is recited at every meeting of the Constitutional Reform Committee. It's a standard agenda item, as it must go back to being recited in the schools until it becomes second nature. You know the music that talks in people's head? Well, these are the words that are going to be talking in our children's head to inspire a new pride in what it means to be Jamaican. That's where we're going. So let's jump over to that schedule. Ms. Wilkins, would you mind taking us through? So it begins with clause 31 on page 38 of the bill? Yes. All
Thank
right.
you, Chair.
Members, please lend the Director of Legal Reform your ears and your attention.
So, after Chapter 9 of the Constitution, Chapter 9A is being inserted. And Chapter 9A empowers the national items that are being put in. So it will become Section 134A. Subject to provisions of this section, all rights of intellectual property in the items hereinafter referred to as the national items listed in the 4th schedule shall vest in Jamaica. So this is to ensure that, having set out the description in detail of the national items, that there is no doubt as to the rights to them. So no one can lawfully take them and make changes to them.
Without the parliamentary process?
Yes, without being authorized to do so.
So, and Parliament is also being empowered to enact law for the management and regulation of the national items, because some of the things will have to be worked out in details and require further consultation. Not everything is going in the Constitution itself.
Yes, that is correct. Things about how they may be lawfully used and presented, there are details that are yet to be put in secondary legislation.
So clause 31 of the bill on page 38 makes amendment with the insertion of a new chapter for national item and a new section. And then clause 32 makes provision, well, clause 34 actually.
It's the
34. Makes provision for the insertion of a fourth schedule after the third schedule. So the fourth schedule deals with the national item, and the national items, please explain the difference between the items and the symbols and the emblems.
Well, this is why they have been classified as items, because they are in different categories. The emblems are the flag, the anthem, and the coat of arms. Those are our emblems. While the symbols, the tree, the flower, the fruit, the bird,
So for those who may be watching, the bill actually in printed form has the flag, and it's gold, not yellow. Black, green, and gold. That's in it. And then we have the lyrics, which are the words, along with the music, the official. And then we also have the symbols printed in the bill. Some people may be using an online version. It should still be in color, but just to show you graphically what it looks like and what we're examining here. And you would see the common name as well as the scientific names or motto, the national pledge, And there is a national song and a national prayer that many don't know. So let's spend a little time. The national flag, I think, you know, the Jamaican flag is probably one of the most recognizable flags, especially because we watch in awe and pride when it is raised in the athletic season, whether on the Olympic stage or on the World Championship stage. Member Golden?
Madam Chair, in particular the flag, I had moved a little ahead of you and I was looking at the national prayer. I actually did not know that we had a designated national prayer. So,
all right, if you're going to deal with that, let us just
No,
go
I'm not going to
through.
deal with it.
Yes.
I'm just opining that. I didn't know. I mean, our anthem is a prayer, our pledge is a prayer. I didn't know there was, this is the first time I'm seeing it in my life. So it buttresses the comment I'm about to make since you started with the flag, which is that we are quite separated sometimes from our national emblems. And the rules, I think, surrounding how they are used by ordinary Jamaicans, what we can do and can't do with it. I think I am advocating, asking that in preparing those at the appropriate time, that the consideration be given not to necessarily readopting the British, what emanated from our colonial heritage in terms of how national symbols and emblems are treated in a monarchical society, but seek to adopt rules of use that allow the people to engage with their national emblems and symbols. A lot of Jamaicans don't know this, but you really can't just take up your flag and wear it, you know. That's not a permitted or appropriate use of your flag. But the question arises, why not? Why not at national events can't a Jamaican hold their flag close to them? I watched yesterday my own son, who is studying in Costa Rica, participating in a competition at his school, and he had his Jamaican flag, which he took with him, wrapped around him. I had occasion just yesterday to say to him, boy, son, that's not really how you're supposed to use the flag, but it was his own demonstration of, I am a Jamaican in Costa Rica. And it was warmly received. So I am saying in my wrap-up, as we prepare the rules in the subsidiary legislation or in legislation to come, that we, from a policy perspective, give some serious consideration, not just to taking what exists now and inserting it here, but to give a new look, a new fresh look at how Jamaicans engage their emblems, their flag, etc., their anthem, etc., because this preamble, Madam Chair, is setting a new tone for how we demonstrate and connect to our Jamaicanness. And I think in that context, it's important that our emblems are not treated like the living rooms in our houses that none of the family can use, but only the guests can come and sit in. Our emblems need to be those things that we can touch, feel, use, and engage with, to underscore and to highlight and to connect to our Jamaicanness? May it please you.
Well, I don't know that I can add to that, but if I can assure you, it is for reasons like that and others why we decided to empower the Parliament to make provisions for the management and regulation of the items, and to do that through a process of taking into account views like that. But as you were speaking about not being restricted by the colonial past and colonial treatment, what we have done in this reform process is to take great care in preserving what we believe should serve us well as part of the legacy of the past that we cannot change. You know, the policy approach is an interesting one of preserving the stability, the familiarity, and the things that have worked for us, improve on those, while taking a deliberate and careful approach to change what has not worked or what has needed improvement. But I've had to dig deep in my library, and I pulled 2 books this morning, well, not this morning, but as I am preparing the brief for the Prime Minister in respect of some of the issues raised by the leader of the opposition. I've taken up a book called Colonial Justice. Beautiful piece of work, which actually chronicles the establishment of the Privy Council. It sets out some cases. But I also have been going through another one which speaks to appellate justice in England and the United States compared, because the issue of the appellate court. And I've pulled them out because I want Jamaicans to know that the approach of the Wholeness Administration in saying that we will have to have a separate conversation on the judicature branch is informed by research, not just abroad, but here in the jurisdiction. You will learn in time how we even come to get the name Supreme Court of Judicature. All of those are set out. But the reason I've referred to the book, Senator Golding, as you were speaking, inviting caution in not restricting, during the American Revolution period, when they were breaking from the past, a number of things were considered and documented. And one of the US presidents, in looking at the documentation, had this to say about examining the benefits of the British colonial system. No, we can't change it. We're not seeking to glorify it. We just have to understand that it is what it is in the journey of our people as a nation. But he said, it brought military strength which provided the security from external attacks. It brought in many areas of technical training which assured economic progress. But more important than either of these, it brought the great ideas which provided the basis for progress in the future. Ideas which will live on for generations after the nations concerned have acquired the independent status for which an enlightened policy has prepared them. The common law, the parliament, the English language, freedom of speech, assembly, press, and religion. These are the institutions which are the proud legacy of the British people in lands throughout the world. I say that to say that in our struggle, we sometimes throw out things wholesale. I know that's not what you were saying, but I want the people to understand that care is taken in this approach, because we can't change the past. We can only seek to learn from it as we take the steps to attain or development aspirations. So we have learned a lot about how national items are handled. We know that some of it is a stiff upper lip that doesn't have any place in the Jamaican society going forward. But there are other important things that we can learn from because they have worked well. and we just need discipline to make them work well for us too. So it's a dynamic approach, quite a dynamic approach. Yes, there are many things that we will have to consider going forward, Jamaica's relationship and ownership with these national items, and that conversation will have to come, and that is why the way it is provided for, even as we move to include them in our goal of Jamaicanizing, is to recognize that more work needs to be done, and so Parliament is being empowered by an act of Parliament to make provisions for the management and regulations. And we have put it at an act of Parliament so that we can agree on them at the next highest level below the Constitution, and it's not going to be left to the whims and fancies of those who feel. This has led me to another point. As we think of the reform and the concerns people have raised, and as we go into the election season, we are retaining the parliamentary cabinet system. It is set out very clearly in the recommendation of the Constitutional Reform Committee why we are not going for the executive presidential system. It's going to be the next issue we discuss as we go into the office of president. And the parliament needs to be understood what that means in a democracy, especially in a representative democracy, and how the parliament should work. And I know this is the exciting next chapter for a Jamaica Labour Party-led government. It's what excites me, because we have a clear vision of what this place, being the people's representative house, should be. So a matter, for example, like the hair policy and the dress policy, that the parliament delegate down to a school board, because everything flows from the Constitution to the parliament to the bodies that are established. And within the system, where once the policies are made, they are accountable to the parliament, because the cabinet is a subset of the parliament, they must come back here for discussion. So, what time come for? Is what we are envisioning the parliament will be. The issues that are near and dear to the people's heart, the representatives that they send here will be discussing them. So that when we delegate the power out to those who are not elected but are appointed, properly a place for appointment, they become accountable to the people. And the policies and processes don't discriminate negatively against our people. I'm so excited about what is to come. All right. So, the national emblems, the national flag, the national anthem. I think all Jamaicans are familiar with the flag and the anthem. And just to say, there is the official music to it. I know in our creativity, we will arrange differently. All of that will be worked out, and provision will be made for that when the creative license, keeping with the creative spirit of our people, is okay, and when the formalities, place and time for everything. The coat of arms, I know already, is the subject of much debate. I want everyone to know that the provision for inclusion here understands that something else may be decided on and substituted on, but there is a coat of arms. And then we have the national tree. I don't know if you are like me, wishing that our streets would be lined with our national tree, and that our parks would be lined with our national tree, and that the policy that was announced by Prime Minister Golden about the 3,000 plants, that most of them would be the national tree and the national flower. And we know the Aki, which is part of our national dish, and we know the Dr. Bird, and we know the national pledge, which is to come. Many may know of the national song, but it may not be so much near and dear to them outside of ceremonial functions. So the lyrics of the national song, I pledge my heart forever to serve with humble pride the shining homeland ever, so long as earth abide. I pledge my heart, this island, As God and faith shall live, my work, my strength, my love, and my loyalty to give. O green isles of the Indies, Jamaica strong and free, or vow and loyal promises, or heartland, 'tis to thee. Senator Morrison, you can share what you were sharing. All right. And the music is to I vow to thee, my country. Yes. It is still sung, yes. But we need to get back to stirring national pride in the breasts of our people. O green isles of the Indies, Jamaica strong and free. Or vow and loyal promises, or heartland, 'tis to thee. We have attribution for the pledge. Oh, I don't see the attribution for the national song. Is that an omission, Ms. Wilkins? The lyrics of the national song. So we have Hugh Graham Sherlock for the pledge, for example, and we have for the national anthem, the Reverend, the Honorable Hugh Sherlock, Honorable Robert Lightbun, Eugene Mapletop Poole, and Christine Allison Lindo. Did we omit the attribution for the national song? Okay. All right. So it needs to be done. All right. So Senator Golden, you spoke about your ignorance of the national prayer. You see, a lot of work was done around independence. A lot of work was done in the aftermath of independence, and it is taking us such a long time to bring together important parts of the work. Still good now as it was then. So the national prayer. Member Davis, would you like to read it?
Let us pray. Let us give thanks for all God's goodness and the wonderful heritage into which we have entered. For Jamaica, our island home, the land of our birth. Response?
Senator Sinclair, you respond.
For the majesty of our hills, the beauty of our valleys, and the flaming loveliness of our gardens.
We give thee thanks, O God, for the warmth and brightness of our days, and the calm and peace of our countryside. We give thee...
I think there is a typo. We give thee thanks, O God. For the warmth and brightness should be in the other line. I think that's a printing error. Yes? Yes, so we will have to address that. The response stops at, O God. We give thee thanks, O God. So we can note that printing error. Yes.
Okay.
So for the warmth and brightness of our days, and the calm and peace of our countryside.
We give thee thanks, O God.
For the rich heritage of our people, coming from many races, and yet one in purpose, in achievement and in destiny, and for the dignity of labor and the service given by every citizen of our land.
We give thee thanks, O God.
Can you read that again?
For the rich heritage of our people, coming from many races, and yet one in purpose, in achievement and in destiny, and for the dignity of labor and the service given by every citizen of our land.
Yes.
We give thee thanks, O God.
For freedom, just laws, and our democratic way of life.
We give thee thanks, O God.
for the high privilege and responsibility of independence, and for bringing us into nationhood.
We give thee thanks, O God.
For our parents, teachers, religious and other leaders, and all those who in every walk of life are helping to prepare us for responsible citizenship, and for all those who are giving voluntary service in the public interest.
We give thee thanks, O God.
For the poets, artists, and thinkers, and all who create in us the vision of a new and better society.
We give thee thanks, O God.
For our godly heritage, the example of Jesus Christ, and the sacrifices of our fathers in the faith.
We give thee thanks, O God.
Bless, we pray thee, our President, our Prime Minister, and other ministers of government, the leader of the opposition, our Parliament, our judges, and all who are sent in authority over us, and grant that under them we may be peacefully and justly governed.
Hear us, we ask thee, O God.
Grant us love and compassion for all those in need and distress, and help us to remove poverty and ignorance from our land. And grant us prosperity and true wisdom, we pray.
Hear us, we ask thee, O God.
Forgive us all that is unworthy and evil in our national life. Establish us in righteousness and inspire us to work for universal brotherhood, we pray.
Hear us, we ask thee, O God.
Guide and bless our nation, we pray, and make us loyal and dutiful citizens through Almighty God, the Father of us all.
Amen.
Amen. You talk about re-preparing us for the rights and responsibilities of citizenship.
This baby new.
It is new.
It was intended to be said in schools and still respectful of the freedom of religion. Yes. Yes.
I'm just inquiring, Madam Chair,
Uh-huh.
because of some of the words that have been used, is it that the national prayer was
Updated?
Yes.
Right. So the president had the queen.
Okay.
Yes. So we had to make some slight amendments.
Does that-
Who can speak to that?
Well, you have answered the
McKee?
question.
Yes,
Yes.
So
because
it's
I've never seen the national prayer,
Yes.
as my colleague
But isn't
said
it
earlier,
beautiful? Strikes all the right notes.
and touches on quite a lot of all the areas that
Yes.
it needs to.
Yes.
Yes.
Yes. So you see, it was the anthem, the pledge, the prayer, the national song, they all came together in a way. But yes, I was explaining on Sunday last that a part of our culture in Jamaica is national services, national church services, marking the start of important occasion. That is the Jamaican culture. Almost every part of government has a church service to mark something. I was worshiping with the Jamaica Constabulary Area 1 group in St. James on Sunday. It is the Jamaican culture. It is who we are as a people, even though so many things reign alongside it. All right? So, yes. So that, yes. Ms. Wilkins?
I just wanted to point out that that this was done in 1962.
Yes.
Ministry Paper 40, tabled by the Ministry of Education.
Yes.
And the author of the national song was Victor Stafford Reed.
So that is
So
to
it
be
will be,
included. Please
yes.
note.
But that is where all of this came from. Okay.
The author of the national song, Vic Reed. Yes. Right, so these matters were actually presented to the Parliament. It's just that the work, the Constitution came into being at the palace in Buckingham. So we're now patriating it, and we're now doing some of the work that really should have happened had it come into effect through another means. Team, any other matter to be raised on the Jamaicanization? Chris?
Only other that comes to mind is the Interpretation Act, but you would have
the Interpretation Act.
Gave some insight earlier.
Right. All right, so that's one of the goals. Now, hear me, everyone. These goals have been set as national goals. Those of us who are given the privilege to be in the Parliament at this time must understand the sense of duty that is upon us. There should be no standing in the way of the attainment of these national goals. As we pick up the pieces of the nation and as we recommit to ensure that we can deal with the real challenges facing the people. We can't deal with it without getting into the hearts and minds of the people about what it means to be Jamaican, about the journey we have taken as a nation so far, and what the possibilities and potentials ahead of us. So, Prime Minister Holness has been very deliberate in not politicizing this process. And some have misunderstood it. But he is firmly of the view that it is bigger than those of us who are currently in the Parliament at this time. But when we are elected to get it done, we must get it done. We must get it done. We can't set national goals about which there is no dispute. And then we start playing politics, forgetting that the institutions we are creating are not for us, but for the people. And it is not what is best for the Labour Party or the PNP, who are the political parties represented in the Parliament now, as they were at the time of independence, in addition to independent parliamentarians. And we have to start refocusing on the dignity of nationhood. I know the economic challenges that we have faced for many decades have reduced everything to a bread and butter issue. But man shall not live by bread alone. And the nourishment that is required is beyond the physical body, but to the mind and heart of the people. Because a lot of what is playing out in the nation tells us about the depravity of heart and mind. And so I don't want anyone to underestimate the significance of this work. We are going to break for lunch, and then we're going to come back for another hour. Would you prefer to just go through and you are hungry? The work is before us. So we have done the first goal. We have the second goal, and we have the other matters. Time is of the essence. And then we will be interacting with members of the public who will come to make.
I'm sorry, I had a misunderstanding. I thought we set the meeting for 10 as the morning meeting for the committee. I did not know this was intended to go beyond the morning session.
Perhaps you were preoccupied at the last meeting and didn't understand that the sittings are full sittings to take us through the work that needs to be done. We have a limited time frame within which to do it, and we must get it done.
I get that we must get it done, Minister. One, I was not preoccupied at the last meeting, and I'm not usually preoccupied.
No,
in
I wasn't
my
saying it
committee
I wasn't
meetings.
saying it in a bad way. I think
But-
there were so many things that were being raised and discussed.
But the point is that I don't recall it being mentioned that it was an all-day meeting, and I have not only been present at the last meeting, I've watched it on YouTube, the full meeting. So I don't recall that being said. So I'm sorry, but I do have other obligations that I have to attend to in my private endeavors. I'm not able to stay.
Thank you, Chair. I too must offer my apologies. I was not aware that we had intended to go all day today, and regrettably, I will not be able to return after the lunch and adjournment.
The other two members? All right, we can perhaps pause today, but bear in mind going forward that we will be sitting fully to go through the matters. We have accomplished primarily what we set out, to take everyone through the provisions of the bill, but we still have to do the deep dive that was on the surface. All right, so we can go up to may I suggest that we look at the provision incorporating the ECJ, and then we will come back to the office of the President and matters related to the office. Let me inquire of the supporting technical team. I don't want to deprive you of lunch. Can we go for another half hour and then we take the break? Is that okay with everyone? Sorry? Yes, no, and then we adjourn for the day. That's all right with everyone? Wonderful. Yes, all right. So for clarity, going forward, when we're sitting, we will sit in the morning, we will take a break for lunch, and we will sit in the afternoon, but not for today. I understand that some members may have other matters. I understand that. All right? All right. So let us talk about the goals of the reform and what we are using the opportunity to try to achieve in the face of consensus. The entrenchment of the Electoral Commission of Jamaica has been a national goal. The work of the ECJ has been commended far and wide. We have had an interesting journey in the democratic process, but I think among the institutions that we have built, that we can be mightily proud of, is the Electoral Commission of Jamaica. And in the presence of consensus about the entrenchment of the ECJ and having a framework that has worked well, and the requirement the alteration requirements to do the entrenchment, the ECJ is being included. So I invite members' attention to page 36 of the bill. The bill is amending Chapter 5 of the Constitution to insert a new Part 5 titled the Electoral Commission. So we have the provision establishing a commission of parliament to be known as the Electoral Commission of Jamaica. The Constitution is setting out the objects of the commission, and the objects are to safeguard the democratic foundations of Jamaica by enabling eligible electors to elect through free and fair elections their representatives to govern Jamaica. The broad functions of the Commission are set out constitutionally to establish policies for governing the registration of electors in accordance with the provisions of enactments. And we know we already have the Representation of the People's Act. Give direction to the person responsible for the day-to-day operations of the Commission on the performance of that person's functions under the laws. And we know this is the Director of Election, Madam Director, Law Reform. And then we have provisions dealing with the conduct of general elections and local government elections and the holding of referenda. Those are the constitutional election functions. And then we have the provision for activities necessary for the discharge of the functions. And one of the gaps that we are filling is to allow for the standing orders of the House to regulate the relationship between the Parliament and commissions of Parliament. Right? That's at clause 32 of the bill on page 39. Right now there is somewhat a gap. We have a number of commissions of Parliament, but we still need a better framework around the relationship between the Parliament and those commissions of Parliament. So those will be provided for in the standing orders, and some people don't understand the significance of the standing orders. They are regulations of the Constitution, and we'll have to get to the stage where they are honored in observance rather than in breach. All right? Yes?
Minister, I think it's important to point out that the Electoral Commission is different in that it deals with the very Parliament.
Yes.
The very composition of Parliament. And yes. So it is different from the other commissions yes. in that regard. Okay.
Yes. Thank you. And it is precisely because of that why it's important to also clarify the relationship. And for those who are listening, it's important that you also appreciate that the foundation of your democracy is a freely, periodically elected legislature, right? So on the indices, when you don't have free and fair elections, when you don't have regular elections, right? Those things impact the quality of your democracy. So I know there's a lot of quarrel about the parliament and a lot of talk, right? The reform of the Wholeness Administration, you know, is deliberately sequenced, because every time we come to talk about the discharge of duties, people used to talk about the pay, right? And so the sequencing of the reform to deal with compensation, to then move on to have the conversation about the performance of your duties, not in a distracted way, but with the level of focused attention that is required to serve the people and to work in the public interest. That's a conversation that is to come, or that is one that is upon us. Right? The research shows that for all of the years of economic degradation in the country, people hold jobs full-time in government while they work full-time on other jobs to hustle a living. And service to the public took second place and sometimes given no place. And it created a culture of government not serving the people. A culture where sometimes the people are made to feel as if they are bothering their servant, those who are to serve them. I want everyone to understand the significance of these reforms in the interest of the people, and especially the people who don't have nobody else in high places. We are relaying the foundations of this nation, touching hearts and minds, and for you to understand what citizenship means, not only by way of rights, but also with responsibilities. So, when this bill is passed into law, the goal that was set long time ago and on which consensus remains, the ECJ will have an elevated status as an institution safeguarding the democratic foundations of this nation. How can anybody want to stand in the way of this goal being achieved? Something on which there is national consensus. All right? Anything that the team wishes to add in respect of this provision? I think, let me just invite members to start considering whether the clause 32, the way that it's been proposed to regulate the relationship between the Parliament and commissions of Parliament, is sufficient. And just bear in mind that it's a general provision, notwithstanding this special nature of the ECJ as a commission of Parliament, but we do have other commissions of Parliament established by law.
Just a question. I was trying to find the provision in the Constitution that delegates the 51. Sorry. Okay. All right, my question is answered. Thanks.
Section 51 of the Constitution empowers each house to regulate its procedure and to do so by the making of standing orders. Yes. Anything? Sorry?
Saying, Chair, that 32 requires some real consideration. I can just, on a first blush, look at it. The standing orders specific to each house, we don't actually have, other than the Integrity Commission Oversight Committee, a specific commission, a specific House committee that deals with commissions of Parliament. If my recollection serves me well, there might be a provision for the Speaker, Leader of Government Business, Opposition Business, etc. But that's something that I think we would want to think very carefully about. But I also think in the context of our recent reform of the governance framework with our public service regulations, removing senators from public boards, from eligibility for appointment to public boards, that how we look at this commission, a committee that would oversee commissions of Parliament needs to be thought through, because is it only a House committee that will do that? Is it a joint select committee? It's not a joint select committee, but a joint committee of members from both houses? Is it Senate committees? Obviously, you're not quite at that place yet, but I do think that I do appreciate the inclusion of Clause 32, because it is something that has troubled me for some time, our ability to monitor and hold commissions accountable, even while they are somewhat independent.
Thank you. I think we may still have to think through. Philip?
Thank you, Chair. Just a minor addition. I'm not sure if you had mentioned it, but that the ECJ would also now be entrenched. So it's 67A is now included under Clause 22 to be included in Section 49 as entrenched.
Yes. Yes, thank you. I think we will need to spend some time looking at how we are going to do it better. You know, all Jamaicans should know that a new way of dealing with the business of the people in the Parliament is coming. New day is coming, right? This is just the work ahead, right? The real things that matter to the people, they're coming in this. We're creating the framework. Even within the ministry, as we were looking on the provision, we still were thinking it through a little further, whether we need to make additional provision, enabling provision. But when we come to discussing it in detail. Any comment, Madam CPC? Do you wish to add? All right. Mr. Harper, any other provision we can quickly deal with in another 5 minutes? Everything else relates to the Office of President and the consequential matters, because we'll have to spend some time looking at the Big Bad 49 separately. So what we have left to know is the Big Bad 49. Yes. The Big Bad 49. Let me tell you, this bill is seeking to do some really significant things, and unlocking of some of the gates without compromising the rail guards for what is to come ahead of us. All right. So at the next meeting of the committee, we will address the issue raised by the leader of the opposition as their condition for participating. Since they were raised here, this forum will be where they will be addressed. And we will then go into the details of the provisions for the office of president. And then the next round of the work will be our interface with members of the public and ensuring that what we are seeking to achieve will be achieved with clarity in the provisions of the bill. Anything that I've omitted to address? The minutes. All right, the minutes. Yes. All right. All right. The other matters on the agenda relate to the minutes which were deferred. The minutes of the meeting are 10 pages. The first page sets out attendance. Anything to be corrected on that page? All right, if there is no correction to page 1, we go to page 2. Prayer, apologies, the welcome and opening remarks, first paragraph of the welcome and open remarks. There is no correction there. Second paragraph. I believe terms of reference should be capitalized because it's a specific terms of reference. Yes.
I'm so sorry. I don't mean to interrupt your reading of the minutes. There was a question I had asked of the Legislative Council on the last occasion. I don't have to stay for the answer, but if she could just respond, I'll catch it on the video recording later on. And can I just ask, the minutes are going to come prior to the meetings in the future? Because I am adamant that we cannot be cursorily reading minutes like this, okay? We have to have some time to review it and look back at it and compare with our notes to be able to confirm minutes. So I would appreciate if we could get them ahead of the meeting.
I will defer the matters arising from the minutes to the next meeting.
Grateful. Okay.
But
I don't know that there was much arising, though.
There you go. Because it was a
but it's a record.
meeting.
It's a record, Minister, and yes. A record, particularly of this committee, is very, very important. Thank you.
Yes. Just before you go, the next meeting will be next Wednesday. Yes. All right. All right. 10 a.m. The third paragraph on page 2. I have a correction to the third line. So she then expressed appreciation for the opposition's position. And I'm asked, yes. Right. So the essence of it is, while I appreciated the position taken by the opposition, as pointing out the differences in the approach taken. All right? So the opposition considers it reasonable to ask that the three arms of government be dealt with at the same time, right? And that's quite reasonable for them. But there are differences in the approach that is taken between the government and the opposition on the matter. Yes? And it's not just the fact that the judicial branch of government was independent, but it cannot be viewed as belonging to either side. It is independent, so a court should not be owned by any side in the parliament. It's a people's court. So while some citizens view... Right, it's a person. Please go on, Mike. Yes.
Spoke to, we shouldn't be at a position where the people had this perception that one court is
right
here and the other court is.
Right.
Yeah.
So I was pointing to the perception of one court being aligned to one side and another court being aligned to one side, but everyone is to understand that the court and the judicial branch is independent of the executive and legislative branches, and we can't approach the issue of which final court as a court being aligned to any side in the parliament, because the court is not about us, it's about the people, and in particular the people who use the court to resolve their disputes. All right? Normally I would propose very specific language for a correction of a sentence. No, right. I'm not pointing to anyone, I'm just saying there are important nuances that must be reflected accurately. Right. So my proposal is that the sentence commencing, she stated that some citizens perceive the CCJ as a PNP court, as a People's National Party supported court, and the Judicial Committee of the Privy Council as a Jamaica Labour Party supported court. I would ask that what follows after is that, but in fact, the judicial branch of government was independent and should not be viewed as being aligned to any side in the parliament. The issue of which final court for Jamaica is about which final court was in the best interest of the people of Jamaica, especially those who use the court to settle their dispute. Right? Any other correction to that page? Next paragraph. There is, right? We go over to page 3. I have a correction to the second paragraph to add the word reflective of the country's identity and nationality. Yes? And the paragraph commencing, the chairman further informed the committee, the sentence which reads, or the part of the sentence, and they would have to decide how far to go in light of the importance of the issue of the final court, which was not closed since there would be time gaps. It's really saying discussions on which were not closed, since there were time gaps in different stages of the process. And the last sentence, she explained that given the stage reached in the life of the Parliament, they were not likely to be able to progress beyond having the bill passed by the Parliament. We have to kind of simplify the sentence and use a simpler tense. But to be inserted if there was consensus and depending on the life of the Parliament. Those were two things. So the passage of the bill in the Parliament, remember it's both houses they would have to pass, and to accomplish that would depend on consensus and cooperation, and also the life of the Parliament, because the Parliament could come to an end before time allows for the different steps to be taken. Given the 3 months that must elapse between tabling and commencement of the debate, and the next 3 months that must elapse between conclusion of the debate and the vote, and then it has to go to the Senate.
Right, but that's what you said. That
Yes.
The life, given the stage reached in the life of the Parliament, you know, that's time.
It's two separate points.
Which is the other one.
So the life of the Parliament is two things. We are already at this stage in the life, but the life can also be shortened. So it's two separate points. All right? And the paragraph, the next paragraph, the chairman revealed that in the preceding week, the work had the benefit of international observers, is the benefit of the views of the international observers, not just the benefit of the international observers. Right? We go over to page 4. Any correction to page 4? Page 5? Would members benefit from some time to read through the minutes and we can complete the confirmation at the next meeting? Because I'm kind of reading the faces of members.
But, thank you, Chair. The pages 4 through to 6 would be the statement made by Member Golding.
Yes.
And so I believe it would have been a copy, a direct copy of what he had submitted. So
Right.
I doubt that there can be any corrections.
Right. I agree with you. Yes. All right, then we go to page 7. Page 8. Page 9. Member Morrison, just look to see what is captured at the top of page 9, which is, it's what you said, just take a look. Page 9. All right. Yes, Member Morrison? Yes, very well. Page 10. All right, will someone move for the confirmation of the minutes as corrected? All right. Seconded? Very well. All right, just a quick matter arising. I will still, in the next meeting, if anything is to be committed. But just for clarity, when we're sitting, please come prepared to sit so that we can utilize the day. Because I know already the schedules of members have a number of things on. So once we come, we must be prepared to go through and do the work. That's one. May I have an update on the notices that were sent out by the Parliament? Please put on record the response.
Right. No, not all the notices have been sent, but Not all the notices have been sent on account of time constraints. Nevertheless, what I did want to mention is that we did get a response from Jamaicans for Justice requesting an extension.
Well, the general approach is not to turn away things, but I also know that unless timelines are given, the truth is that the bill was tabled on the 10th, and on 10th of December, and on that occasion, for all, I made it clear that anyone who intends to make a presentation should go ahead. I understand, you know, an unfortunate part about the Jamaican culture is that sometimes we don't want to be constrained by time. We just want to go on and on and on and on and on. And we feel that any attempt to put time boundaries in place is a fetter on freedoms. Quite the contrary, it requires a discipline. We're not really turning away anyone, but the work needs to be done in a timely way, you know. And so for those who are requesting, we will consider your submission. Just make sure that they come in a timely way. But we have set some time boundaries that we have to work with. All right? Let there be no mistake. I'm not saying we're turning away anyone. I'm just asking for respect for time boundaries and cooperation. Because if we're going to get it done, we have to do it as timelessly as possible. And the research shows that there's been a lot of talk about constitutional reform and very little reform itself. Because people don't appreciate that talking about it outside the parliament is not going to get it done. And our books are replete with examples of the extent of the talk without our getting it done.
Yes. As it is quite interesting where the request for the extension of time has come from. Having heard a report this morning on one of our media, from our media houses, where they brought a story speaking to a discussion that involved the same organization criticizing Parliament for having delays in respect to a joint select committee. So it is quite interesting. But I do agree with you that in respect to the work that has to be done by Parliament, that we set the timelines, because some of them go on quite long, unnecessarily so too in some respects. And as you have rightly said, Madam Chair, this discussion didn't just start yesterday. You went through the Constitutional Reform Committee and prepared a report which was submitted to Parliament, which was quite extensive. We have that document here, but I have the nice one now, too. Yes. Right. And so you went to the extent of putting this in this format, right? The bill was laid some time ago too, and for the record, your committee report was in May of 2024. So we have gone several months, and there is not much difference from what is contained in the bill. And persons would know, and with some amount of experience too, that particular organization which are participating in several JSCs on different bills, that this is where the process would have come to. So I would have thought that persons would have started to put their thoughts together in respect to any contributions that they would have wanted to make. So timelines have to be set, and I support your position on that.
Thank you, Member Sinclair. I just add that I appreciate that we have moved from recommendations, and certainly we have a difference we have modified a recommendation in response to feedback. But the truth is that, you know, many of the things that the Parliament is criticized about is really a reflection of what is happening in the society. and we have to come together. Matters before a certain forum have to be treated a little differently. Now, I don't wish it to be misunderstood. I'm not saying I don't understand constraints. I'm just asking that we respect the time boundaries within which we are operating. I know the significance of the changes being pursued, and I understand that it will be, some will digest them a little slower. It is precisely why the whole reform process is designed at a slow pace, but we really have to get on with it if we are to achieve these national goals that we have set. All right. Any other business?
Thank you, Madam Chair, and thank you, members. I'd like to take this opportunity in any other business to address the question that was asked by Senator Golding Campbell at the last sitting. At the last sitting, Senator Golding Campbell asked, how is it determined which standing order is applicable to any one select committee where you'd have both houses, members of both houses, sitting and deliberating about one specific issue? Based on the research that I have done, I've recognized that we've really been operating on a convention. None of the standing orders for either the Senate or the House of Representatives have identified or clearly established what standing order is used when we have joint sittings. In that lack, I have looked to other jurisdictions. I've recognized that in the United Kingdom and also in Canada, I believe, there are actual provisions for in the first meeting of that joint committee, the resolution would be created with all the members outlining the standing orders that are to be used, how it is that the meeting will happen procedurally, the expectations and objectives of the meeting, and ensure that same is tailored according to the resolution that has created the committee in the first place. In light of that, and based on our specific context, it may very well be prudent that when resolutions are being made in the respective houses, that it be a part of the resolution as to a determination what standing order applies to the committee. If it is not done at that stage, perhaps some guidance may be had at the procedural meeting, meaning that very first meeting of the committee where rules about quorum, rules about, well, the membership would come from the motion, so certainly rules about quorum and any other procedural rules as to how the committee will continue or deliberate on its business, perhaps it may be considered at that meeting which standing order applies. But to date, all we have been operating on is a convention. And that convention is whatever house started the motion for the committee, that is the house that they've often used, the standing orders for that particular house that they've actually used. And even in the face of that convention, there has been some deviation from my findings. Typically, I found that it is the House of Representatives, their standing orders, that are often used in joint select meetings. So I appreciate the question that was asked by Senator Golding Campbell, and certainly it has brought to the fore need for reform. I know, too, that that question is coming at a very good time, an ideal time, because the Senate has been going through a rigorous process in amending its standing orders to ensure that it is modernized. and it is reflecting fairness and justice and good democracy. The House of Representatives, they are also trying to catch up in their own amendments. So we're finding that there's no concurrence between the standing orders anymore. How they started was pretty much the same thing. What were the rules in the House of Representatives were typically the rules in the Senate. But we're finding now there is a divergence because there have been amendments made to the Senate standing orders. So good question, and certainly something for us to look into further amendments and to create rules that could rectify these gray areas. Thank you.
Thank you. Thank you, Council. I'm happy that it provided you with the opportunity to do the research. Research is an exciting place and an adventurous journey. Takes you to on the path of discovery, but conventionally the standing orders of the House prevail for joint select committees, all right? And conventions also are part of the constitutional law and the law. So the next research you'll do is to look at how law is defined in Jamaica, and you'll see what that includes. All right, so the first place, if there's a gap in our standing orders, then the standing order themselves tell you who you resort to, right? And we have a guide, so we go to the UK Parliament, and the Mays on parliamentary proceedings assist us. It is now a moot question on how similar should the processes be, but constitutionally each house is given the power to regulate its own affairs, right? But some things need to be standardized and some things would have to be different, bearing in mind the different composition of the house. But what is exciting is that we are in the season of reform, and the product should be a better product at the end of the day. I'm sorry Senator Golding is not here to get the answer, but I think she kind of got it, the short answer. Conventionally, it would be the House. But you did raise some other issues with the gap in the reform work in the Senate and in the House around the standing orders. These are matters that we will have to look at, and that's why the clerk to the House is now being formally incorporated in the law revision process, because we are connecting the dots. They were connected at one time and somebody chopped them up and fling them out. That's what happened with the economic issues, right? Independence don't just come so, you know. We have been on bended knees, dependent, serious logic to the approach that we are taking. All right, is there any other business? There be none. It's now 1:50. Oh, the date and time of the next meeting, as previously indicated, will be next Wednesday, the 30th. It's next Wednesday, the 30th.
Next Wednesday is
Huh?
29th.
29th.
But it would have to be in the afternoon because there's like some committee on the other in the morning.
All right, so we are meeting at 2 next Thursday because there is a Senate committee meeting that is set for 10 next Wednesday, Wednesday the 29th. Hold on. 29th, yes. We had indicated both the 29th and the 30th. When we come on the 29th, we'll see, because I know there may be a schedule conflict in respect of the 30th and a request to assist in some public education around the constitutional provisions on freedom of religion. Chris, is that the date? Right. 29th is at 2 p.m. is indicated, yes, 2 to 5, the earliest, 2 to 5. So don't expect us to adjourn before 5, but it could be after 5. All right? And Thursday, we had also indicated an afternoon, 2 to 5. Once members are familiarized with the bill, then it will set the stage for us to engage with members of the public who will then express their own views with what they see. Another presentation is to come to the committee, and it's on the parliamentary cabinet system and representative democracy. So you can understand some of the choices that have been made in this reform context. All right? But I invite members to just also look on the rationale in the report of the Constitutional Reform Committee on some of the recommendations being implemented to assist your own understanding of the bill and the policy behind the bill. I'll also invite Dr. Barnett. At some point, I had spoken to him, one of our experts on the committee, to be in attendance to help to take the committee and the public through some of the provisions of the bill. All right? So it's now 2 minutes after 2. We can move for the adjournment. Very well. See you next week at 2. Can I just ask you not to run off, please? We just have a slight conversation.
Please, one at a time. I can't hear all that. Taxi for room 97. Okay.
Could you sign for this, please?
Oh, did you hear that, Fergus? Taxi for room 97?
Yeah, I got that, dear.
And I would like some tea with that milk and sugar. Oh, and 2 biscuits.
Oh, yes, Mr. Doe. Hello, is that room 97? Yes, your tea is here.
No, I ordered the tea.
Hello? Hello? Oh, fiddlesticks. This phone isn't working. Oh, what a problem. Oh, what am I going to do without a phone, Isabel? Got it. Ha! I can use the backup phone. Phoebe, Elmo. Oh, is that you, Elmo?
Hello, Uncle Fergus. This is Elmo and the backup phone.
Oh, tell Phoebe that there's a broccoli here for room 452.
Okay. Phoebe, there's a carrot who wants to go to the zoo.
An elephant? Has lost his shoe?
Okay. Uncle Fergus, there's an elephant on Phoebe's toe.
What? An elephant on her nose? What?
I am not an elephant. I am a broccoli.
I know, I'm sorry.
Rather amusing to see you using such an old phone system.
Well, it's quite frustrating, actually. These cans don't really work.
Then why don't you yodel instead? It will help you solve your communication problem.
Oh, are you here for the yodeling convention?
Yes, I am. I and 27 other yodelers. Yodel-a-hee-hoo.
Yodeled back.
You see, where I come from, yodeling is a way to communicate. It's how we talk to one another. A yodel can be heard over mountains or throughout a hotel.
Oh, right. So I just go, yodel over libby libby libby.
No. Yodeling is an art. It must be taught. Luckily, that is my job. Yodel instructor. Professor Fleece, at your service. Yodel-a-hee-hoo. Good morning, Furchesters.
Good morning, Professor Fleece.
Welcome to Yodel class.
Oh, yes.
Thank you. I will now introduce you to some basic hotel yodel.
Oh, that's exciting.
Sorry, me late. Sorry. Whoa, sorry. Oh, this me chair.
Shh.
Yodelay, yodelay, yodeloo. That means your taxi's here. Now, you try.
Yodel,
No. You're all yodeling at once. Let's try practicing another way.
Sure.
Let's start at the beginning, shall we? It all starts with a yodel. Yodel. And then you add an a-hee-hoo. A-hee-hoo. Now put it all together and that's how you say hello. Yodel-hee-hoo, yodel-hee-hoo. And don't forget the hee. Yodel-hee-hoo, yodel-hee-hoo. That's how you say hello. Yodel-hee-hoo, yodel-hee-hoo. And don't forget the hee. Yodel-hee-hoo, yodel-hee-hoo. That's how you say hello.
that was wonderful.
Bravo! I think you've got it.
Me got question.
Yes, Cookie Monster.
Oh, yeah. It actually more of statement. That terrific bow tie.
Thank you, Cookie Monster. No, anyway, anything else you want to say is in your basic hotel yodel book.
Oh, wonderful.
You are now official graduates of Professor Fleece's basic hotel yodel class. Yodelay, yodelay, yodelay. That means congratulations. Class dismissed.
Well done, everyone.
He remember question.
Ooh, yodel. Ooh.
Excuse me. Excuse me.
Oh, sorry, Mr. Dull, Harvey. I didn't hear you. I was yodeling. Yodel.
Yes. Have you ordered my tea?
Your what?
My tea. I ordered a cup of tea with milk and sugar and 2 biscuits.
Ah, yes, I remember. Only I don't know how to order tea in yodel. Let's have a quick look in the book here.
Excuse me. I'm sorry to bother you, Mr. Fudge, but I am still waiting for room 97. Apparently somebody ordered a taxi.
Oh, that's right. Well, let me just have a look in the book here for order a taxi. Yes, here we go. Yodel. Oh, what did you think of that? Pretty good, wouldn't you say?
Yodel. We heard your yodel.
Is the taxi for us? Are you in room 97? Oh, then it's not for you.
Could you please order my tea?
We just remembered room 24 wanted a wake-up call. Yodelay, hee. Yodelay, hee.
Are you trying to wake us up?
Are you in room 24? Oh, then no. We didn't mean you.
We forgot. Is it yodel, odel, eeny?
No. That's me one stripy sock, see? Yeah.
Oh, yeah.
Me one cookie
Yeah.
is yodel-nom-nom.
Oh.
Yodel-nom-nom.
Me want cookie?
We didn't order cookies.
Has anyone seen a taxi? I called for one 2 hours ago.
Have you tried yodelay-hee-ho, delay-hee, cha-cha-cha?
Yodelay-hee-ho, delay-hee-cha-cha-cha. Oh, wait! Stop! Shush! Oh, Fergus, how do you yodel? Please stop yodeling.
Oh, here we are. Yodel-odel-hop.
Thank you. Oh, we seem to have a problem with our yodeling. Can someone please explain why each time we yodel, everybody answers?
Because, my dear madam, we don't know who you're yodeling to.
Your yodels are heard by everyone. Oh. So our phone's not working.
And we can't use tin cans.
And nobody knows who we're yodeling to.
Oh, this is a huge problem.
This is a catastrophe.
It's more than just a slip up or a mess up or a mishap. A threat, just a catastrophe. We need to fix it fastrophe. Once it's in the pastrophe, this simply cannot lastrophe. Or just a catastrophe. The problem is so vastrophe. We're really flabbergastrophe. Let's ding the bell for blastrophe. Catastrophe, catastrophe. Catastrophe, catastrophe. Catastrophe, catastrophe. Oh, it's a catastrophe. It's a catastrophe. What a disaster. It's a catastrophe.
So we
have a catastrophe on our hands. How are we going to communicate with the right guests?
Let's put our fairy heads together and think. Oh, yes, I know. Let's learn all 923 room numbers in Yodel.
Oh, that's a great idea. If we work at it day and night, we'll have those numbers.
Excuse me. Your phone's unplugged.
So that's what the problem was. Thank you.
There, problem solved. Now you can call any guest you like and you can order my tea.
You mean Elma doesn't get to yodel anymore?
I really liked yodeling.
Well, of course you can yodel. We can yodel over the phone. Watch. Right, I'll order your tea, Mr. Dull. Yodel-o-hee-ho.
I should have ordered the tea myself.
You really can't be going. They say it isn't true.
The Furchester will never be as furry without you. Don't check out.
Don't check out.
Please, 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 please don't go.
Don't check out.
Don't check out.
No, 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 no. Please, please don't check out.
Underwork your tea time, underwork your drink. Underwork your tea time, underwork your drink.
Come July, your NHT home improvement loan will increase to $3.5 million for qualifying applicants. Your government is caring for you.
Here in the Caribbean region, our climate is changing, resulting in intense heat as temperatures soar. This increase in temperature is having a significant impact on our energy sector.
With the increase in temperatures, we of course are expecting an increase in the use of electricity or cooling, etc. So there's an increased demand on the utility companies to, provide for that overload on their systems.
The hotter it gets, the more energy need there is for cooling among the population, but also the harder it becomes for electricity to be produced. So the efficiency of electricity production is typically also lower when it's really hot.
But there are ways we can help. Simple actions can make a big difference.
There are certain measures that we can take to make sure that we mitigate some of the possible impacts, such as using LED bulbs.
It's up to all of us to take proactive steps. Stay informed and prepared. Together, we can weather this storm. For more information and updates, follow CIMH on X, Facebook, and Instagram.
Motorists, as Minister of Justice, I appeal to you, obey the road code, pay your ticket on time, and only go to court if the ticket is being contested. Close to 80% of matters coming to the parish courts are for traffic breaches. Let's work together to make our roads safe and ease the burden on our courts.
We want a piece for Jamaica. Yo, what are you? Oh man, none of that. No, brother, no, man. Mash up that.
Can I see you ever play ref? Dirty game,
yeah,
man,
but
please.
a little bad game. No, I said, place you come from, brother. I want to live good, man. I want to live good, brethren. No shake hand, I can play a little bad, brethren.
Really have to shake hand?
Yeah, man, and no badness, brethren. Just live good, man. That is it. Come together, also, and make the violence done.
It must stop. It have to stop.
Gang violence is not the solution to our problem. It will only cause pain and suffering. Let's find non-violent ways to solve our conflict. Let's work together to create a safer and peaceful Jamaica. Let's all live good.
A message from the Ministry of National Security.
Make food.
I make food.
Place you order if you lucky. We make food in our foodie truck. Oh, the alarm! We got it.
I got it.
Hi, I would like a breakfast made by monsters.
Oh, well, you called the right truck, because we are Monster Foodies!
What I'd like for breakfast is food that's round and flat, like a circle. It's my favorite shape. Could you help me, please?
Well, that's easy.
Yeah.
Cookie, round and flat.
Cookie's not a breakfast food.
It not? That news to me. Nom, 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 nom.
Oh, I know. Pancakes!
Oh, that's a good idea, Gonger.
Yeah.
Pancakes are round and flat like a circle.
Yeah.
Here are the ingredients.
Oh, and the banana.
Yeah, banana, right. Okay, there we go.
And the maple syrup.
Oh, boy,
what?
there's no syrup.
No syrup?
Yeah.
Oh, we need to get the fresh maple syrup. Oh, you know where I get maple syrup from?
Maple trees?
Yeah.
Really? Me was kidding.
I'll show you. Come on.
We're going to the maple syrup farm. Hello, Mrs. Farmer. We need maple syrup. Can you help us, please?
Well, you monsters came to the right place. This is where we make it.
Oh, do we have to bring the whole tree home?
No, this is only the first step in making syrup. This is called a spile. It's drilled into a maple tree.